Hi everyone. Okay, I hope you can hear me. Please confirm that am I audible to you today? Can you hear me? Thank you, Leong. All right. So we are moving on from where we stopped yesterday. We have done particularly on the two major areas, okay, on the tort law. Today we are also continuing with some of the most prominent areas, okay, that besides negligence law, students mostly wanting to have some good strategy in terms of preparing yourself for the examination. Okay. Now today we are looking at tort of nuisance, Rylance and Fletcher, together with trespass to land. Okay, if there is any attachment on those kind of elements in those questions under the tort of nuisance. I've already sent these materials earlier, okay, yesterday and also before, and which means all the necessary materials that I wanted to share, okay, whether the earlier materials and also the additional materials already been sent. In the event there is any form of, okay, request or upon discussion, you may need something or I feel that something else need to be shared, I will definitely do it, okay, via speed eventually when we are uploading our recording. Okay. Let's, without any further ado, move on to the tort of nuisance. As far as nuisance is concerned, as I mentioned yesterday, if I can remember, all right, of course, we have done some part of the questions, right? Let me share the screen first. It involves generally three types, three areas. All right. And as we know, Rylance and Fletcher is also considered to be a subspecies of nuisance, even though it can be discussed separately. So 2022, I believe that this is what we have addressed yesterday. Okay. We have addressed yesterday on this question. I have moved on to just to recollect back what I've done yesterday. 2022 Zone B, yes, we have also ran through together with Fern and Tate, okay, the new dimension of discussion on the viewing of from the gallery, those cases, and also the past year question that has arisen accordingly. And there were 2 October questions in 2022, just to highlight with guidelines only. And I believe that we're supposed to deal with 2023 today morning. But okay, let's straight away go into the question. Question 8, Zone A, 2023. I read, Cold Spring Water have operated a sewage management service in the village of Longfield for 2 decades. The time frame play a crucial role. As we can see, for 2 decades basically mean 20 years. Yeah, they've been running this business. And what they are operating a sewage management service. It's in a village, right, locality. Fred and Gladys have lived in Fir Tree Cottage on the edge of the village for 35 years. So they'll be living for 35 years, which means almost 20 years, okay, they have been experiencing, okay, the sewage management service. Now, in the last 3 years, Cold Spring sewers have begun to overflow into properties in Longfield every spring and autumn. So there was some issues pertaining to overflow of the waters. The foul-smelling water has destroyed many of Fred's valuable rose bushes. Okay, destroyed. There was a destruction, or rather, we call there was a property damage. At times, the couple finds it impossible to sit in the garden of Fir Tree Cottage. Okay, and at times, which means the smell. So we have 2 issues here. Okay, at times, the couple find it impossible to sit due to the smell. Many of the residents, these are coming to the overall population, okay, many of the residents in their neighborhood have begun to develop physical symptoms in the spring and autumn. Martina is in the live-in nanny, okay, for the children of Scott family who live next door to Fred and Gladys. She believes that her migraine headaches. Martina, take note, live-in nanny. You must also look into who is the claimant. Here, Fred and Gladys, they are, okay, living there. So the presumption is they are owning the property, whereas Martina is a live-in nanny. So take note, who is she basically? Is she a person who owns a property or she is actually working there? Okay, it's a live-in nanny anyway. So she believes that her migraine headaches, also a kind of a physical or personal injury, okay, right? Migraine headaches are aggravated by the exposure to the sewage water. So there are a few issues you can discover, and there are elements of arguments that you can put forward on the defense side of it, and the kind of issues that we can see. But main issues are definitely okay in terms of the cause of action. One is nuisance. One could have been what we call this public nuisance or so. Okay, then again there can be a question on whether you have the right to sue. There can also be an issue whether, right? Sorry, I think there's an issue of the coloring. Wanted to make it clear that the color. There's also an issue whether, okay, are we able to discuss, right, any other thoughts besides what we are talking about today? So general remark from the examiner, this popular problem question raises standard issues, nuisance, public and private. There could be an issue of discussion of Rylance and Fletcher because of the overflow and possible negligence. Possible negligence. Yeah, nuisance problem question almost always include these four aspects, and candidates are made aware of the importance of considering them. Yeah, right. So what are the authorities that is relevant, okay, and in the mind of the examiners for the students to ensure that they are highlighting? And I have actually incorporated some information that requires for us to reflect ourselves from what we have learned. The courts apply a rule, okay, from this Bamford and Turnley, right? Baron Bramwell, if I'm not mistaken. Yeah, correct. Baron Bramwell. His lordship said this. This is a very important statement made by Baron Bramwell that has always been used by the judges, okay, right up until now. Even Lord Gough, okay, in the case of Cambridge Waterworks. Yesterday, I was trying to recall who was the defendant in that, but claimant, okay, in that case. Cambridge Waterworks against Eastern Counties Leather, right? A rule of give and take and live and let live. This is a very popular caption, or rather the rule set by, okay, highlighted by Baron Bramwell. And seek the balance of convenient and inconvenient. So nuisance is not a kind of a setup liability, likewise unlike negligence and other torts. It's always a balancing interest between the both neighbors or two parties. Right. So we are citing Bamford, and we are also citing Dalton against Henry Angus, okay, old case also, because the courts will be looking into the competing interests between the two parties, okay, that is as per Lord Blackburn, right? And the next case that is relevant is Malone and Lasky. This concerning interest in the land, okay, you can also add on about the submission of interest in the land from the case of Hunter against Canary Wharf, okay. These are the pairs of cases that will be very important for students to use to show that, okay, Malone and Lasky was affirmed, right, by the courts, okay, the House of Lords in Hunter and Canary Wharf, okay. It concerns interest in the land. You must have an exclusive possession. Then only you can bring an action for nuisance. So, in the words of Lord Gough, on the authority as they stand, an action in private nuisance will only lie at the suit of a person who has a right to the land, okay. So, we need to see who are the parties involved here, right? Two of them, Dan and Gladys, if I'm not mistaken, Fred and Gladys, okay, who are staying there, owning a house. That's a presumption we can make because they've been staying there for about 35 years, right? And now we have also another issue where we are referring to our friend that is Nanny, right? Who doesn't have an interest in the land. So can she sue? If she can't sue under nuisance, probably we may need to highlight on any other thoughts that is relevant for her. That is where, okay, you may seek to get some ideas from negligence on that part. But comes to residents, yes, right? Generally, right, you do not need to have an interest in the land so long, okay? It is a class action. That is fine. Class action, that is fine for them to take, okay, a suit under public nuisance. Yeah, so you have private nuisance, public nuisance, but we need to identify who has the right under private nuisance, okay? Hunter and Canary Wharf also played an important role to show that not every type of interference will tantamount to nuisance. There are generally types of nuisance that usually, okay, can be taken action against, actionable in the nature, i.e., for example, okay, which I mentioned yesterday, one is physical damage to property. Yes, there is a possibility of taking an action under nuisance. Secondly, encroachment, okay, encroachment. And the third one is, okay, interference with the quiet peace and enjoyment of land. So the interference with the quiet peace and enjoyment of land, okay, by way of precedent, we can understand it involves, okay, noise, dust, smell, okay, uh, uh, probably, okay, we can talk about oil, grease, but not television reception, interference with the television reception. So, Hunter and Canary Wharf is set to limit, okay, not all actions can be taken by all interference. Okay. And then moving further, okay, relevant cases cited by the examiner, Barnett and Chelsea, as to the causation, right? Causation element, AGPYA quarries, right? Talks about public nuisance. All these things we have, in a way, we have run through, because I need to go into the guideline already. Bar and BIFA is a case that has been added, okay, from these particular aspects of the year, right? Bar and BIFA 2012, a bit of a reading that I'm doing now. A case where the operators of a waste tip started to process pre-treated waste. So when we are talking about like sewerage, overflow of dirty waters and all these things, students can actually, okay, add to their, authorities in their list of preparation, the case of Bar and BIFA, water waste services, where it's about pre-treated waste that was more smelly than the sorts of refuse that they had previously processed at the site. Raised an important question: will a use of land be held to be reasonable when it has been permitted by regulators of the activity? So at first instance, in this case, Justice Colson reasoned that the large-scale tipping of waste as landfill is a necessity of modern society and the best, perhaps the only, way in which non-recyclable waste can be disposed of without causing significant harm to the environment. And that the consequence of a waste tip would be a reasonable use of land if it operated in accordance with permits granted by the Environment Agency. However, our problem here is there is no indication whether the regulators have actually, right, approved the activities of the defendant. Okay, I go back, defendant, Cold Spring Water. Right, we don't see. I in my observation, when I read, I don't see it. But we can presume they've been running for 20 years. Definitely, if they are not having this license, they could have been, challenged by the authorities already. That's one thing we can presume from the facts. If it is silent, then we can say that they've been running it accordingly. But then again, okay, even though you have the license, but are you, all right, doing that activity, right? Even though it's socially benefiting, within the, okay, framework or allowed, okay, parameters, okay, of the, okay, dangers that you are not supposed to create for others. So that is our concern, that we can actually discuss and argue, right, on those points, because you're looking into the injury sustained, and you realize that there was no overflow in the beginning of the years. That shows that something would have been wrong. Okay, so this is how we can actually indicate to the examiner eventually. So in the judge's opinion, okay, for this case, in the judge's opinion, this approach avoided the unsatisfactory position of common law liability for private nuisance being out of step with the statutory framework regulating waste tips. Now, another authority, Rylance and Fletcher, what Justice Blackburn had said, okay, I believe that everyone can reflect the famous quote by Justice Blackburn in the Court of Exchequer Chamber, where the rule of law is that the person who for his own purposes brings on his land and collects and keeps there anything likely to do mischief, if it escapes, must keep it in at his peril, and if he does not for so, is prima facie liable or answerable for all the damage which is the natural consequence of its escape. So, however, there are two variations developed after Rylance and Fletcher that students need to take note. Number one, the decision of Rylance and Fletcher, or rather the dictum, okay, made by the House of Lords, right, pertaining to the what you brought in to the land. So the House of Lords mentioned it's supposed to be a non-natural user of the land. And that created a lot of what we call complication or complexity as to what is meant by non-natural user of land. Okay, that is one. Secondly, Rylance and Fletcher seems to be a strict liability tort. Okay. However, okay, when we were looking into the decision made by Lord Gough in Cambridge Waterworks against Eastern Counties Leather, right, where his lordship, okay, said that foreseeability of harm is important, requires an important requirement, okay, in order to, determine whether the defendant is liable or not. So the moment, okay, that particular element or requirement been added by Lord Gough, it became questionable as to whether Rylance and Fletcher is still a strict liability tort. The answer is definitely is no longer a total strict liability tort because of the element of foreseeability or requirement of foreseeability. However, okay, some what we call this, some academicians are still saying that there are circumstances that foreseeability, all right, should not be used in Rylance and Fletcher. But then again, okay, at the end of the day, Transco against Stockport has settled the ruling by saying that, yes, foreseeability should be a requirement under Rylance and Fletcher. That shows that Rylance and Fletcher no longer, okay, a strict liability tort. It's no longer a strict liability tort. So Lord Hoffman suggested that a useful guide in deciding whether the risk has been created by a non-natural user of land is therefore to ask whether the damage which eventuated was something against which the occupier could reasonably be expected to have insured himself. So it is on the part of the defendant, okay, what he should have insured himself. You are dealing with waters, waste. You should be careful that if it leaks, it can cause problem. If you have rearing some, vulnerable animals, okay, then you got to be careful. Or if you're storing chemicals, then you got to be careful because it can cause problem. But if you're storing water as usual, right, or you're storing some plants, okay, or keeping some plants which can be a bit smelly, in a small, okay, quantities, then might not be on a reasonableness basis, okay. You need not be insuring yourself already. So it depended upon each and every circumstances of the case to decide whether, okay, it is a non-natural use of land or not. The phrase seems to be very complicating and misleading. But when we try to look into what the judges are trying to explain, then we can process it according to what the House of Lords said in Transco PLC. Yeah. Another case of relevance under this area of torts, Marsick against Thames Water. A bit of reading. Recognize the potential for huge public liability in such actions. All right. And citing both statutory authority as well as a wide margin of appreciation for individual states given by the European Convention of Human Rights, have refused to permit Article 8 to have much impact in this area. because the common law in itself developed quite well, okay, over the, I would say, decade or centuries. So there's not much of room for the human rights come into the picture here, right? So the facts which can be useful for us to consider together with the question itself is when Peter Marsick here brought a claim against his statutory water and sewage undertaker, Thames Water Utilities Limited, complaining of its failure since 1992 to prevent persistent external flooding and backflow of foul water from its sewer system into his home at times of heavy rain. Although it was reasonably practicable for TWUL to prevent the flooding, okay, look at the statement given, reasonably practicable to prevent the flooding, it has refused to do so. So under its then scheme of priorities, there was no prospect of such works being undertaken in the foreseeable future. After 9 years, Marsick turned to law and brought this action for damage to his property in nuisance and under 1998 Act. So although his claim in private nuisance was rejected at first instance as contrary to the existing authority, right, Justice Harry QC had approved the claim under human rights, founded on impeachment of the claimant's rights to privacy and family life and peaceful enjoyment of his possession, Protocol 1 for Article 1. So the Court of Appeal in supporting Marsick's claim in private nuisance rendered any claim under Act is unnecessary because this can be, okay, the action can be taken under, right, the common law private nuisance in itself. So looking into this kind of situation that has been highlighted by the examiners, okay, right, we are referring to water, sewage system, then these are some of the main authorities you can use. And if at all it has been repeated, then it is useful for you to use these authorities in your examination. So some common errors for you to take note of together with good answers. You can read up yourself. All these are basic advices given to students to ensure that we do not make a mistake here. Answer guideline, okay, which I'm going to highlight to you today. The question presented involved multiple potential causes of action from the overflow of sewage into properties in Longfield by cold spring water, including issues of private and public nuisance, potential liability under Rylance and Fletcher, and negligence. Okay, as an introduction, students can briefly outline the factual background. Okay, the material part of the facts where Cold Springs Water Sewage Management Service causing overflow, right, into Longfield, affecting Fred and Gladys' property and health of the residents, including Martina. So what we need to do is we need to state the potential legal issue to the examiner and then moving on to the first, okay, cause of action under private nuisance. Define private nuisance. We can also define in many ways from various academicians. However, one such, okay, definition I normally prefer to use will be from Winfield and Jolowitz. Okay, an unlawful interference with a person's use and enjoyment of land or some right over or in connection with it. How do we apply? They have a clear interest in the land as homeowners. How? Because they've been staying there. I mean, that is a presumption we make. You're staying there for 35 years. So we can cite Malone and Lasky here and Hunter and Canary Wharf to support our claim. Point number 2, the sewage overflow constitutes a direct, substantial, and unreasonable interference with their use and enjoyment of their property. So we need to argue balance of convenience, right? But that has been upset by Cold Spring action or inaction, actions or inaction. So how, I mean, on the part of Fred and Gladys, when you are applying and discussing and arguing and making a submission, that is quite straightforward, won't be much of a problem in terms of Fred and Gladys on the part of, right to sue. But comes to Martina, we have an issue because she lacked the interest in the land because she's a live-in nanny. Okay, she doesn't have the legal right, okay, or even equitable right for the matter. Okay, she could potentially argue for indirect effects and she has suffered special damage beyond that suffered by the general public. So she may bring an action under public nuisance, but there is a difficulties here posed by the requirement of an interest in the land again, okay, unless it goes into a society at large, okay, to sue. So Martina can actually join residents there together under public nuisance, where it's an act that materially affects the reasonable comfort and convenience of life of a community. But if it affects people, like there's a special damage, there's a damage to property, then it's quite easy for us to take an action under public damage. Even if it is a what we call a migraine or other we call personal injury, then so long that you can show proof in the court of law that there is causation element is established, then there can be an action against public nuisance. Even one person is taking an action, likewise in the case of Bolton and Stone. But there again, Bolton and Stone, the frequency was not so high for the courts to allow public nuisance. But this one is like gradual, effect happened to Martina and others, yeah. So application, the repeated overflows affecting Longfield could constitute a public nuisance affecting a significant portion of the community. So we are referring to, as I said, the authorities is on top. If you want to refer, you can. We are referring to AG against PYA Forest. And then you make a submission accordingly. Okay. Third cause of action possible will be Rylance and Fletcher. A person who for his own purpose, blah, blah, blah. I mean, what we have said about what Lord Blackburn, Justice Blackburn mentioned in the case of Rylance and Fletcher. So how do we apply this principle? From the facts, Cold Springs management of sewage fits the criteria of bringing and keeping something likely to do mischief it escapes. Yes, there is a possibility. Sewage, yeah, can cause mischief. Smelly, you can feel the smell, no, at the radius of, I would say even 200 to 300 meters, right? So definitely, it's not good for the surrounding people on that matter, you see. So the natural consequence of the sewage overflow directly damage Fred and Gladys' property, right? Direct damage occurred to Fred and Gladys' property. So Rylance and Fletcher deals with, right, direct damage, consequences. Rylance and Fletcher is not applicable, if you are suffering discomfort. No. Rylance and Fletcher only applicable if there is a physical damage, right, or foreseeability of physical damage, in other words. So we need to discuss whether sewage management is a non-natural use of land, considering Transco Stockport for modern interpretation. So we can discuss based on, all right, the requirement of non-natural use. Students may also want to, add the case of Cambridge Waterworks, foreseeability of harm as an added. But I don't see foreseeability is an issue here because why? It's an overflow and there's a direct damage can be seen, and overflow of the sewage is definitely a foreseeable kind of consequences. And sewage can be classified as non-natural use in that sense because it can cause mischief, right? More often than not, like, chemicals, acids, and so forth. Yeah. Okay, what about negligence? Is it possible? Cold Springs owes a duty of care to Fred and Gladys and potentially other residents, including Martina, to manage sewage without causing harm. Right? So the duty of care, physical proximity can be seen because they are neighbors in a way. So there's no issue with the duty of care here. However, when you are looking into the breach, is it possible? Failing to prevent sewage overflow. Failing to prevent the sewage overflow despite it occurring repeatedly. I think the knowledge here is quite clear. And are they do anything about it? If you fail to prevent a sewage flow that can cause harm, then you are clearly in breach of duty of care. Because the magnitude of harm can be seen. Right? Magnitude of harm can be seen. The frequency can be seen already because it has been overflowing quite often, in other words. Then, as usual, for negligence, we are using causation, but for Thames, Barnett, and Chelsea, that establishes damages would not have occurred, but for Cold Springs negligence. What are the damage? Property damage to Fred and Gladys and possible health impacts on Martina and other residents. Since Martina cannot sue, right, under private nuisance, she may take an action under negligence already. Well, possible health impacts, unless she can prove it, okay, based on the causation element. But property damage, but not for discomfort. Discomfort, you can't sue under negligence. For discomfort, smell, dust, noise, you can only sue under the rule in Rylance and Fletcher. What are the defenses available for the cold spring? Any possible defenses might raise, including statutory authority, regulatory compliance, okay, referring to KBA against BIFA, wastewater services. All right. Student also can add, okay, the defense of prescription. You can also, this is just a guideline. You can also add other defenses that comes into your mind. Right? The prescription, okay, you are running the business for more than 20 years or 2 decades, then I think it should not be, actionable already, the activities there. But then again, the last 3 years only, there was an overflow. It's not like 20 years it has been overflowing. That was different issue. These last 3 years, the overflow started to occur. So on that basis, the defense of prescription might not be, okay, successful. There's no clear indication about statutory authority or regulatory compliance, okay? So it might not be successful in that sense, right? And the court might not be willing, okay, even though you have the authority to do that. So, but you still need to follow certain regulations, okay, or compliance, right? If you breach those compliance, then again, this defense may not be available. So what kind of remedies you can argue for? 2 remedies possible. One is injunctive relief, injunction, stop the activity. All right, stop the activity. Or stop the gravity of the activity so that it can avoid the overflow. Yeah. Continuous overflow, in other words, also. Yeah. So that is form of injunction that you can seek for. And whatever damages that have been suffered by the parties there. Okay, you need to compensate, okay, financially them. Yeah. Conclusion, summarize the whole process, that what you have done. So always put a summary of the entire answer, okay, in your conclusion to ensure that the examiners are able to see, okay, this is what your end product going to be for each and every part of discussion. Yeah. Okay, so that says, if you have any other things to ask from this question, feel free to chat. All right, that is for 2023 Zone A question. Whereas 2023 Zone B, we are going to that. See whether how different or how similar this question can be with 2023 Zone A. Question 8, with permission of the local council, there is a permission granted. This is only a permission, remember? It's a permission. A Youngstown Rugby Club has begun to hold fundraising car boot sales every weekend on their club grounds, weekends, next to a small industrial estate. Okay, locality here. Small industrial estate. Every Sunday, cars pour into the area from all over the country. Local residents feel, this is collective, collective. Local residents feels that the area has completely changed due to the noise and traffic. It's an issue. Noise and traffic. It's not about damage, but it's about inconvenience. The sale visitors often drop rubbish on the club grounds, some of which has blown into the garden of White Hart Inn. So rubbish blown, rubbish on the club, but some of it blown, okay, into the grounds of White Hart Inn, which is the next door to the club. So what is this all about? Is it a rule in Rylance and Fletcher? Is it about, okay, nuisance, or is it about negligence, or can it be a trespass to land also? When the owners of the inn complain, there was a complaint made. That means you are trying to ask them to stop, but the club ceases to empty the waste bins on the ground. So what happened? Rats are drawn to the bins, some of which are straying into the grounds of the inn. Okay. Advise the parties now. So this question is quite different from the earlier question, in other words. So what are the general remarks and authorities the examiners are expecting from this set of questions? Popular, straightforward problem question raises standard issues of nuisance, public and private, violence and fletcher, and possible negligence again. Okay, coming to cause of action, they are similar to the above. Nuisance problem question almost always include these four aspects, and candidates are made aware of the importance of considering them. Okay, so no way you can actually escape Rylance and Fletcher, even though some students want to select, can I do Rylance and Fletcher or Lucent? There's no such thing. You have to understand all. Cases of relevance, Bamford and Tenley, Supra, before, just now we discussed already, Malone Lasky, Hunter and Canary Wharf. Additionally, Christie and Davies here. What Christie and Davies says. The state of mind of the defendant would also seem to be relevant in assessing whether defendant's use of their land is reasonable or not. This part is relevant. I.e., when I ask you to make sure that you clean up the rubbish, but that again, the club did not do anything about it. So here the plaintiff succeeded in obtaining an injunction when her neighbor, frustrated by the noise of music lesson in her home, expressed his annoyance by knocking on the party's wall, beating trays, whistling, and shrieking. So in the words of Justice Nord, what was done by the defendant was one only for the purpose of annoyance, and in my opinion, it was not a legitimate use of defendant's house. Please use this phrase. Okay, legitimate use. You can use this phrase in the examination. A very good way of tackling whether you are using it in a very reasonable manner. Okay, it was a legitimate use or not a legitimate use. Playing the guitar, music, beating trays, whatever, whistling, all these things can be done in a separate, clubhouse, but not in a house. Okay, and continuously I'm talking about is annoying the neighborhood. So, of course, the activity is done, okay, in a right place because authority is given, statutory authority is given, permission is given, not authority. Permission is given. But there again, okay, are you doing it in a very reasonable manner so as not to disturb the residents, okay, nearby? AGPY Quarries, Bar Bifa, Rylance and Fletcher, Transco PLC, all these cases to be used, which I have discussed with all of you. Adams and Ursel is another case that can be relevant here. It's about running a fried fish shop in a residential part of a street. The court granted an injunction restraining the defendant from carrying on his fried fish business on the premise. Of course, permission will be given. When you run a business, definitely you get a license from the local authorities, yeah? But then again, okay, when you are causing nuisance to your neighborhood, definitely it is an issue, right? It is an issue. And rejected the argument that the closure of the shop would cause great hardship to the defendant and to his customers. For me, it was a cheap source of nourishment, right? So the court looked into the balance that an injunction can be, unless you are running a very huge business, right? Very huge, very, very big activity, like the case of Milan Jackson, right? Cricket ball ground. That is a very socially worthwhile, socially useful activity, and it's a very, very huge activity for the nation, right? Rugby ground, race course, football stadium, okay, and so forth, right? So, but an individual business, okay, is something, okay, can be discussed, okay, based on whether injunction relief can be granted or not. So Adams and Ursel is a good authority. Whereas in Canaway and Thompson, yeah, the activity is very big. But yet the court still granted injunction more for a quiet time injunction, they call injunction for certain period of time in a week, not a full injunction. So Canaway and Thompson will be relevant for that. Okay. I need to read Canaway because it will be useful for some of the important questions, especially about activities that run by a bigger organization. Yeah. In 1969, the claimant built a house near a man-made lake, which for a number of years had been used for a motor boat racing. Defendant were held liable for the nuisance created by the noise, right? And at first instance, the claimant was awarded damages with 16,000 pounds, right? There was an appeal made. Allowing the appeal, the claimant was entitled to an injunction limiting the use of the lake. Injunction limiting the use of the lake, all right, to a certain days and to certain noise limit. You see, this can be done. Courts can grant such an injunction. Injunction is quite discretionary and varied. You can actually, right, modify the way how injunction can be put into action, right, as an order by the courts. So this is useful whenever you see exam question, how are you going to design the type of injunction that the court can grant to the claimant if they are successful, especially when our friend is doing the activity that cause a lot of noise, and it is not asking you to stop, okay, 100%, but there can be a variation in your injunction. So Canaway and Thompson will be a good authority for students to use for that purposes. Right. And yeah, the rest of the part you can read. Right. Gillingham against Medway. Another additional authority for this type of question purposes. What Justice Buckley has said, that planning permission to develop a disused naval dockyard as a 24-hour commercial dock had changed the character of the neighborhood. Local residents therefore could not complain about the serious disruption caused to them by its operation. However, when a planning permission is given, you need to understand, the court is quite clear later, that we need to understand, just because there is a planning permission does not mean that the court will shut their eyes, or you can shut your eyes, or whatever damage or inconvenience that you are causing to the neighborhood. That should not be the matter. That should not be the case. Statutory authority is different thing. Planning permission, yes, local authorities can grant planning permission, okay? But they will always set some rules and regulation, and sometimes you are doing it within the rules, but yet you're causing harm because people cannot foresee every single thing that happens. But under the strategic development, okay, or in the local authority, local areas, they will always give you or grant you such kind of permission. But without, may not have realized, okay, what kind of, right, effect, okay, that can cause to the neighborhood. So this is one of the reasons why eventually, okay, the Supreme Court had to sit again, right, to make a very determined, okay, deliberation on such kind of problem that occurs within neighborhood. And this was decided, okay, somewhere in 2014, I think, if I'm not mistaken, the Coventry against Lawrence, and that was the case I'm citing, and students will need to use this case more profoundly in examination, especially comes to injunction. Yeah, Coventry and Lawrence reviewed the extent to which planning permission might change the character of the neighborhood, where the defendants had long-standing planning permission to build a speedway racing stadium and later permission for a motor cross track. Sometimes you are given a permission, later you're modifying, you are extending it, you are expanding it. All right. Until such extent, suddenly people started complaining. So Lawrence, who had moved into the area in 2006, alleged that there was a noise nuisance. Supreme Court overturned the decision of the Court of Appeal that the grant of planning permission had by itself changed the nature of the locality. Supreme Court said no. Just because you are given a planning permission, that does not mean the nature of locality changes. It would be wrong in principle if, through the grant of planning permission, a planning authority would be able to deprive a property owner of a right to object to what would otherwise be a nuisance without providing her with compensation. Of course, injunction might not be granted because of the activity is huge, or injunction can be granted with some limitations, that's all. Well, at the same time, compensation need to be granted also. Because of the noise, the value of the property can be diminished or can be reduced, in other words. So the court will need to consider the diminution of value of the property that is at hand because of the noise that has been created. The value of the property depending on the surrounding circumstances. You build a house near industrial area, the value is not so high compared to residential area or near the high-end what do you call high-end area. High-end means depending on what kind of area is that. Is it a upper class area, lower, in terms of the financial hub they call. So it depends the value of the property, or it depends on the condensed area or flare area, open area. So all these are to be considered, especially property valuers. They know very well, okay, what is the valuation that can be put on the property. All right. So common errors is to focus almost exclusively on private nuisance and to omit public nuisance. Students should look into public nuisance also and violence. Whether it's applicable or not, okay, directly or affirmatively, but discussion is a must. That's what examiner always telling. So we don't omit. Somehow or other, we have to consider whether there is a possibility of violence and fracture. But in this case, you can also look into, right, what we call the trespass to land, the rubbish. There is a possibility of trespass to land. That one, even though the examiners are not focusing on, but you can always cite. There's no harm in doing so. Answer guideline for this question. Let me just reduce a bit. Font. A bit okay. Too big. The font. It runs out. Okay. Answer guideline. As an introduction, possible, okay, cause of action, private nuisance, unreasonable use. I mean, the definition, let's ignore that. Look into the application to White Hart Inn. Increase noise and traffic. Cite Canaway and Thompson as noise issue. All right. Litter and rat infestation. Reflect on Christie and Davy regarding the defendant's conduct exacerbating nuisance, suggesting a deliberate worsening of the conditions of the rugby club. So discuss the significance of the landowner's rugby club state of mind and actions post-complaint, which exacerbates the nuisance. They did not do anything about it. Okay. What are the defenses possible? Rugby club might have, including coming to nuisance principle, which is not applicable anyway. Right? Sturgis and Richmond, that is the authority, right? The coming to nuisance is not a defense for the defendant. You can run the business for 20 years. Yesterday I moved in, I can sue you today. Doesn't matter, right? Public nuisance, an act or omission that materially affects the reasonable comfort of the society there, number of people over there. Yeah, car boot sales impact the local residents. So that comes under public nuisance already. We can refer to AG against PYA queries on that matter. Negligence. Yes, possible application to rat infestation. Infestation, if at all occurs, even though it's not a direct thing that you're doing, but indirectly it has caused all this thing, which it can be said to be a foreseeable consequence by you keeping the place dirty, not clean. So on that account, okay, the people there, or rather the infected party or affected parties, can sue the defendant under negligence. Yeah. Violence and fracture is possible. Explain why the doctrine may not apply. Accumulation of rubbish and subsequent rat infestation does not constitute a non-natural use. Rubbish alone is not a non-natural use of that context, we can say. However, okay, you can take note, I didn't put it here because this is a general guideline. However, you can argue, if possible, trespass to land. Yes. Right? Flow of the rubbish, okay, right, due to the blow of a wind. Yes. It can be a trespass to land. Offend one of the old authorities I've read before. It should be in one of my notes. Yes, it is possible. Okay. If you send me an email asking which authority, then maybe I can check back all my notes. If I check now, it will take a little bit of time. But if you send an email, I can give you the authority. Trespass to land, the rubbish that actually due to wind has flown to the neighborhood. It comes under trespass to land also. Okay, planning permission. Yes, students can use authorities of Gillingham Medway in support of the defendant. Coventry, which is a more prominent authority in support of the claimant. Yeah? Planning permission alone is not sufficient. Hence, students can make a final conclusion on this account. Having said that, we are done with 2023 questions. So now we are going to go into more structured, approach by referring to 2024. Okay, you have gone through some of the authority with variation in different types of question. And right from the different types of torts, okay, from the ambit of nuisance, okay. And then most of the time you could see that the examiners are asking problem-based question on nuisance because it is more interesting for the examiners to cover all 4 topics at one go instead of asking an essay question. But anyway, we will look into the recent authorities and see what kind of possibilities that may appear, all right, for this year examination. Okay, let's continue straight away. Before we take a break, I'm going to refer to the materials that I have sent yesterday on May 2024, nuisance, Rylands and Fletcher. Areas. Right. Let me share screen. Right. Give me a seconds. Recently, we have had gone through a judgment in our court in Malaysia pertaining to a nuisance issue. Okay, it's not a nuisance; it's landlord and tenant, and eventually the tenant had to leave the house due to the complaint. Okay, because this tenant is a person owner of a company, right? He has actually brought in foreign workers and stayed in one of the what we call apartment in the one of the apartments, house. So what happened? Of course, foreign workers sometimes, okay, you may discover that they might not, okay, fulfill certain criteria of the neighborhoods, okay, like cleanliness, smell, and so on, because they stay in a group. Where the neighbors started complaining, and eventually the owner of the business, okay, the tenant, had to vacate all his workers out because people are complaining. Local authorities started asking what happened, why so much or not noise and no smell. But there's an agreement between landlord and tenant. So since he left earlier, the tenant left earlier, landlord started suing for compensation of the unpaid rent and also the future rents according to the agreement. So we had to defend on ourselves, okay, by bringing in, the issue of the forceful vacate. Forcefully, we have to vacate ourselves because if not, we will be bound by a legal suit under nuisance. Because the neighborhood, the neighbors can sue for nuisance because of the smell and noise and so forth. So that was the kind of issue that can crop up, in the court of law, right? So that is based on the activity done in a house that caused some problem. But it is linked to different issue, landlord and tenant issue. So we have to defend, on this side by justifying ourselves why we need to leave the place, premise. The court had to finalize their grant of damages to 25% instead of 100% claim. Okay, that was a successful. I mean, of course, you are still breaching the contract of landlord and tenant, but then again, you can actually defend yourself by highlighting the foreseeable consequences in future. Even though the other neighborhood has not sued you, they didn't sue you, all right, for nuisance yet, but foreseeability is already there. Okay. Okay, 2024 Zone A, let me read the question. Nancy has recently opened a rescue center for wildlife. Tiggy Wings, wildlife. open a rescue center. Get into the okay. Rescue center, wildlife givings. In her large back garden, in a village, Three Oaks, village area, the locality, village. Birds, squirrels, rabbits, hedgehogs, which are found injured or suffering, can be brought to the givings. So that means more like a rescue care center, where they will receive skilled care and rehabilitation. This has resulted in increased traffic. That's an issue. Increased traffic on a quiet residential street, with visitors to Tigiving sometimes blocking neighborhood driveways. Blocking neighborhood driveways. An aviary at the back of the garden, which is full of songbirds, is noisy. It depends. Like yesterday, I was talking about the neighborhood, okay, praying with the bell, with the smell of the camper and so forth. Yeah, it can be disrupting the neighborhood, but depends. People love or not. Songbirds, songbirds. Some people love songbirds. They like to listen to birds chirping in the morning. Right. Of course, birds are not, I'm not sure whether it's going to be noisy throughout the day, but there again, it's an imagination we need to have in this kind of set of circumstances. Yeah. Now, Mr. and Mrs. Scott, who moved next door after the founding of the Givings, cannot enjoy their garden due to the noise and smell coming from Nancy's property. So there is an issue, noise and smell. Noise and smell. Mrs. Scott's mother doesn't have an interest in the land. Please take note. When they say someone else might not have interest in the land. Even Mrs. Scott, we are not very sure she has an interest in the land because it depended upon whether you are joint owner or not. Sometimes you can argue under Human Rights Act because you are an equitable owner, not a legal owner, if it is a matrimonial home. All these are information that you can't see it in the question, but possibly you can actually insert in discussions. Yeah. Who lives with them cannot sleep due to the noise of the birds. Animals attempting to escape have damaged the fence between the two properties. Damage the fence. Okay, it's property damage occurred. The fence is owned by Scots. Recently, a pair of squirrels escaped. And ate their carrot crop. Okay, and one of them bit Mrs. Scott, personal injury, when she tried to intervene. Okay, could have been a contributory negligence. It doesn't matter. All these are okay, should ring our mind, the bell of the mind to say that, okay, what could have been these issues? But substantially, you can see the whole scenario, what area of law, but there are one or two variations you could see from this question. Yeah, general remarks. This popular problem question raises standard issues as usual. Okay, right. Coming to law, I'm moving down. Bamford, Malone, Hunter, repeated there. Hunter, Canary Wharf. Okay, Hunter, AGPYA Quarries, Bar Vifa, Rylands, Cambridge, Waterworks, Transco, Human Rights Act 1998. So seems to be not much of a deviation from the earlier authorities suggested by the examiners. Common errors, let's see. What students are continuing to do, kind of errors. This question saw a degree of good performance. Yes, no issues. Most common error is to focus almost exclusively on private nuisance. Please do not do that. That is why all my guidelines, just put a caption. Break it down. Because nuisance is a very large topic. I know, I understand. If I don't, I was discussing just now, everyone asking, sir, what about all the factors are we not supposed to discuss? What about the main requirement, the whole structure? What about all the defenses? Yes, I understand that. We don't say no. But comes to nuisance question, always limit with relevance. That's all. What is relevant? what authorities that we need to put. Even though we know so many authorities, it's not about how much we write. Are we writing the relevant information or relevant authorities for the question or not? So that you can have a fair share of discussion with other significant thoughts such as violence, negligence, or even a bit of a trespass to land, not necessary, but maybe that's a bit of relevance in a question. Right, having said that, then the usage of non-natural use. Remember the ruling in Transco. Please do not make a mistake on that also. A good answer would consider all possible causes of action. Right? Would include issues of defenses and remedies. Must always look into them. Defenses and remedies. Good organization, possibly based around IRAC system. Issue, rule, application, and conclusion. Sometimes they call ILAC. Your lecturer might use ILAC. Issue, law, application, and conclusion. You normally use IPAC. Issue, principle. And I don't really use IPAC. I use issue, principle, application, conclusion with some analysis. Normally I do that. I will always put some argument and analysis in my application, then only conclusion. All the different types of damage and clear writing are always important. Then the poor answer is definitely not following the above. Let's take answer outline here. It's 10:31 already. Can we take a break first? First break. And then we will get into the answer outline. 10:31, we can join back at 10:40. First break for about 8 minutes, just good enough. We will meet at 10:40. Okay, we are back in action to continue with our nuisance. Nuisance May 2024. Answer outline. Yeah. Okay, so as an introduction, you can actually highlight the scenario which engages several tortious causes of action. Right, as usual, okay, students can go for a standard introduction, public, private, nuisance, violence and fracture, and potentially negligence and trespass, if you see there's a possibility of trespass. The core legal issues involve the interference with the use and enjoyment of land, escape of animals. Please highlight the material facts of it, okay? Escape of animals, physical damage to property, and injury to persons. The advice will focus on Nancy's potential liabilities to Mr. and Mrs. Scott and Mary. Private nuisance issue, whether the noise, smell, and animal intrusion from Nancy's rescue center amount to an unreasonable interference with Scott's use and enjoyment of their land. So you can highlight, once you have identified the issue, highlight to the examiner what is the issue. Of course, you write it in an essay form. I'm just putting it as a guideline only. The issue is whether. So here, I'm putting it as a pointer form, easier for you to see it clearly. So what is a principle that we can actually refer to? What is private nuisance? Is the unlawful interference with a person's use and enjoyment of land. It can arise from noise, smell, physical encroachment, provided the interference is unreasonable. Okay, citation, Hunter or even Bamford and Turnley. Okay, Hunter is better because there's more recent authority. But Bamford and Turnley, you can cite based on what Baron Bramwell said. Earlier, I already cited those things. This is just a reflection of what I said earlier also. What is the application? This is the part that varies the standard of the students. Okay, very important in the sense of application. How do you discuss and argue? The Scots complain of persistent noise, smell, and animal escape. The noise from aviary and smell from the injured animals are arguably unreasonable to a typical resident. Physical damage from escaping animals further supports the claim. All right. However, Mary, lacking a proprietary interest, cannot sue. Although the rescue center has public utility, this does not override private rights. Okay. Courts assess reasonableness in the light of locality and duration. In this context, persistent disruption in a quiet residential area is likely actionable. So you make a conclusion, simple conclusion. Scott can have a claim or not. Mary, on the other end, may not have a claim here, right? Coming to public nuisance, you students can add any other authorities possible, but just align yourself accordingly. Align yourself accordingly. Public nuisance part, whether the traffic congestion and driveway obstruction caused by visitors to givings, interference with public rights, and whether Scott suffers special damage. In principle, we can refer to AGPYA queries. Okay, even private individuals may sue if they suffer special damage under public nuisance. Okay, right. Public at large, they can sue for interference, no problem. So we can make an application here, right? Example, increase traffic and block driveways, potentially interfere with the public highway use. If others are similarly affected, a public nuisance exists. Whereas the Scots may show special damage because they are individual if their access is persistently blocked. But what special damage they can argue? Then they need to show proof in the court of law. Okay. So here courts are cautious about recognizing public nuisance for residential access issues unless there is a wide impact, because it's not something that we have seen clearly in our precedents, okay, that residential, the blocks of the road or whatever can cause public nuisance. So the claim success depends on the extent of public inconvenience. Then possibly the court may allow. So a limited public nuisance claim may lie if the widespread obstruction is proven. So on the facts, please look at it whether you can argue that this is a widespread public nuisance, widespread obstruction, or is a normal obstruction to them. That is on public nuisance. What about Rylance and Fletcher? Whether the escape of animals from Nancy's land imposes strict liability under the rule in Rylance and Fletcher, if you want to say it. Under Rylance and Fletcher, a defendant is strictly liable for damage caused by the escape of something brought onto land for a non-natural use, which escapes and causes foreseeable harm. So please take note, the foreseeable harm part that you can also add the case of Cambridge Waterworks against Eastern Counties Leather. Rylance and Fletcher per se is a strict liability tort, but you must add foreseeable harm by highlighting the case of Cambridge Waterworks. Application: Nancy keeps birds and squirrels. While these are accumulated, their escape may not meet the non-natural use threshold post transco, which restricts liability to extraordinary uses of land. So when you are running a care center, sometimes more birds come, sometimes less. You're not keeping it forever. It goes, comes, and eventually it has been given out, these kind of things. So very, very difficult to determine the point whether this can become a non-natural use of the land. But some students may want to argue that out. Okay, no harm, okay, by saying that it is a non-natural use of the land. Whereas in Rylance is now narrowly interpreted. Okay, sorry, I didn't read this one. Damage to fence, and crops occurred. And personal injury, the bite, is not recoverable under Rylance and Fletcher, because Rylance and Fletcher is only recoverable for physical damage, not personal injury. Only for physical damage, not personal injury. Okay, authority is Transco. Transco has made it clear. Again, that it is for physical damage only. Courts are unlikely to view Wildlife Rescue Center as a non-natural use. So the claim may fail to meet strict criteria. So it's unlikely to be successful under Rylance and Fletcher due to modern limitations. What about negligence? Are we able to sue successfully under negligence? Whether Nancy owed a breach of duty of care to Scots by failing to prevent her animals from escaping. This is possible. Why not? Because yes, we are not disturbing you. Yes, you have to take care of your birds, but you are not able to manage. You are not able to do certain preventive measures to ensure, okay, the birds are not escaping. Are you doing anything to that? Even if you have done something, but is it reasonable? Reasonable means good. But on the facts, nothing was shown that Nancy tried to prevent. So it's much easier if at all you're looking under negligence. So to succeed in negligence, the claimant must prove duty, breach, causation, and loss, remoteness of damage. So reasonable foreseeability of harm is crucial in this context also, right? You can also highlight a reasonable foreseeability of damage, okay, under Wigan-Mount principle, okay, where birds may, okay, cause personal injury if they bite, okay. They can be vulnerable to people, okay, at some times, especially injured birds maybe, right? Depends. It depends on how you would like to apply and argue. Here, Nancy owes a duty to neighbors to contain animals. Failure to secure the enclosure breaches this duty. Crop damage and the bite were foreseeable consequences of this breach. Negligence provides a flexible remedy not confined by the rigid doctrine. Okay, right. So the liability under negligence is more likely compared to Rylance and Fletcher. So this shows that Mr. Scott, all right, can bring a viable claim under negligence instead of Rylance and Fletcher. Yeah, possible trespass to land. Whether squirrels' entry onto Scott's land without consent amounts to actionable trespass. Animals are moving around. So that can be highlighted based on the case of League Against Cruel Sports and Scott, 1986. Trespass occurs with any unauthorized physical intrusion onto the land, including by animals. So how do we apply? Squirrels entering Scott's garden and damaging crops constitute direct interference, and consent is not present here. So trespass is an actionable per se, right? Strict liability, again, and complements nuisance and negligence. So it provides a foundation for injunctive relief, but limited compensation unless damage is also shown. Yeah? So you can highlight trespass and you can highlight one or two cases accordingly, which can be very relevant to that. So Nancy is possibly liable for trespass due to animal intrusion. So you can just conceptualize them. Then you are actually able to expand or whatever discussion or argument or additional authorities that you may put with one core authority that is relevant for the issue at hand. Yeah? What about defenses and remedies? Is there a possible defense coming to nuisance? Yes, it will fail. As a matter of law, you can't raise this defense. Sturgis and Bridgman, even though Lord Danny, Miller, and Jackson did suggest that there is a possibility of this defense come into play, but there again, majority in the Court of Appeal in Miller and Jackson says no. So hence, Sturgis and Bridgman still a ruling authority to say that coming to nuisance is not a defense. So what remedies available? Damages for loss of enjoyment and property damage. Injunction, yes. Restrict noise, smell, or enforcement. So you can use cases like, Canaway and Thompson, right? Miller and, not Miller and Jackson. Canaway and Thompson, yeah. Miller and Jackson is more special damage. Yeah. I think Canaway and Thompson is more useful authority because there's a limitation that you are actually giving. Courts balance public interest and private rights. Okay. So then once you've done already, then you make a sound conclusion to yourself where there is a balance of public interest and private rights. Injunction may be limited or suspended to allow compliance, especially where the defendants perform socially beneficial acts. That one also we need to compare how the courts are balancing the interest where the injunction to be given. If injunction given, is there a limited injunction or not a full-fledged injunction, depending on the activity of the defendant. Compensation is granted, can be granted because any losses suffered or personal injury. This scenario illustrates overlapping tortious liability and nuisance. So students sometimes, will need to highlight to the examiner, how generally you want to say about nuisance. For problem question, you don't have to, but sometimes, if you can highlight your point of view, the examiners will love to read. Okay, so I will always tell the students to put some reflections into your answer. If you have the time, no hard and fast rule on that. But if you have the time, show some difference compared to, any other, students. So some reflection will be very useful. Always put forward something that you want to put forward at the end of the answer for the examiners to take note of what you are trying to say about this particular piece of thought. Sometimes it might not be 100% relevant to the question, but it's relevant to the overall perspective of the thought in itself and how are you perceiving it to be based on your reading, based on something comes to your mind that you know about the particular thought. Yeah. So that is the reason why I always put one caption of paragraph to the students to tell, why not you talk about this? Okay. Having said that, we are done with Zone A. Now let's look at Zone B. I think I would like to change it to normal font, because I know, so that it doesn't create the brightness to my eyes. Okay, let me read the question. Two Rivers Council has obtained planning permission to open a children play park on a quiet residential street. The park contains a wide range of play equipment and has been planted with a wild meadow garden. There is now, so they have a planning permission here. Children play park on a quiet residential street. Okay. And they have play equipment and they planted with a wild meadow garden. There is now an increased level of noise. And the children and the parents, which disturb the neighbors on the street. Okay. Buggies for transporting babies are left blocking the pavement outside the park. Similar to A question, left blocking. Alfie aged 85, trips over one of the buggies and breaks his ankle. So there's a personal injury. And Alfie definitely not someone that owns the land, because she is or he is outside the land, outside the home, trips over buggies and breaks his ankle, So this is not something that can be argued under private nuisance. Probably a public nuisance and probably negligence. There is a small practice football pitch used by some of the older children. Footballs are frequently kicked into the garden of Ivy House. This is similar to Bolton and Stone and Miller and Jackson, the cricket ball, kind of a situation, right? And where the Singhs have recently moved, making it difficult for them to relax outside. So difficult for them to relax outside. So that means a bit of an annoyance by the balls, right? And it has broken a window, one of the balls, in Singh's conservatory. Similar to Miller and Jackson again. Take note. You can highlight this case also. Seeds and pollen from the meadow have blown into Singh's garden, causing weeds to grow, all right, the flower beds and aggravating Mrs. Singh's hay fever. So that shows that this is somehow a question to be highlighted based on Rylance and Fletcher, this part. Rylance and Fletcher part. And there's a hay fever, personal injury. So whether you can claim for personal injury, right? So advise the parties. General remarks. This popular problem question raises standard issues of public nuisance, Rylance and Fletcher, and negligence. Nuisance problem questions almost always include these four aspects. Okay, right? I think I don't have to read this part. This part is almost similar. Only the authorities, any new authorities highlighted? No, similar authorities that we have done. Common errors, good answer. Okay, let's get into the this student extract also I prefer you to read because you have done already. You may be able to encounter where the good part that you would like to use and what are the issues that you may see that the student might not perform well on here. Okay, that is on the part. Comments on the extract. Okay, now let's see our outline here. What I'm trying to say. This scenario involves claims of private nuisance, public, and as usual, start with your introduction, right? And the parties must be analyzed, okay, and they are affected by what generally, So, and then you go into the detail, like private nuisance means things against Two River Council mean what is an issue? The issue whether noise, footballs, pollen, and weeds from the park amount to unreasonable interference with Singh's family, enjoyment of their land. So private nuisance, as usual, can cite Hunter, Canary Wharf, Bamford and Turnley. Claimant must have a proprietary interest. No issues here. But what the Singh's experiencing, okay, here are noise from the play area and parents. Footballs entering their garden and breaking the conservative window. Pollen and seeds from the meadow garden causing allergic reaction and weed growth. So while play park serves a purpose, public purpose, the frequency and severity of the interference, especially property damage and repeated football intrusion, point toward actionable nuisance. The pollen issue may engage bar and BIFA. Pollen issue may engage bar and BIFA, where indirect effects, odors, and pollutants were found actionable. Now, we also look at the locality, as in the case of Sturgis and Bridgman, where the street was previously quiet, and now it has been affected by such an activity. So the park has actually alters the character of the area. Although Coventry Lawrence affirmed the planning permission, which is a factor, but it does not legalize nuisance. Okay, so hence, there is a highly likely that the parties are, the defendant is going to be responsible here. And I'm adding it here on this question that we are talking about, okay, the pollen and hay fever complaint may be dismissed as it can be sensitive, it can fail on the issue of sensitivity. You may be oversensitive on that, yeah? And unless shown to affect ordinary individuals. Hay fever is also an issue because can you sue? Can you sue someone under private nuisance or not for personal injury? The answer is if the personal injury is direct, you cannot sue. But if the personal injury is received, or rather you suffered, all right, as a result of physical inconvenience, all right, then possibly you can claim as a consequential loss. Possibly you can claim under the consequential loss. Yeah? But other than that, we are referring to Robinson, which I've given the authorities yesterday, Robinson and also McKinnon, about sensitivity of the claimant in itself. Other people might not be so sensitive about it. Okay, unless shown to affect ordinary individuals. So the Singhs have a strong private nuisance claim, especially in relation to footballs, yes, and potential property damage. That is one. Secondly, on public nuisance, how do we look into the issues? Whether buggies blocking pavements interfere with public rights, and whether Alfie's injury amounts to special damage. So here we are looking into Alfie, 85-year-old man, and also the buggies blocking the pavements. Similar to earlier question, the blocking or interference of the driveway or right of way. So under public nuisance, again, we are referring to the key case, AGPYA quarries. A private individual can sue if they suffer special beyond the general public. Okay, how do we apply? Briefly, pavement obstruction by buggies affects pedestrian use and may constitute a public nuisance. Alfie, age 85, suffered a fractured ankle after tripping over a buggy. This physical injury constitutes special damage, giving him standing to sue individually. However, courts are reluctant to impose liability unless the interference is substantial and widespread. So the council may be liable if they fail to manage or mitigate ongoing obstruction. So Alfie may have a claim under public nuisance based on the special damage that he has suffered. But student also can argue this out. If at all you are referring to Bolton and Stone. But in Bolton and Stone, okay, the frequency of the ball coming out is very less. But here you can distinguish. Yeah? Here, frequency of football, the balls coming out of the ground is quite frequent. So on that account, you can distinguish and argue for Alfie under nuisance, under public nuisance. That is possible. But he can also argue under negligence eventually, later, for the balls coming out and you are suffering from personal injury. Okay, now, that is on the public nuisance part. Confine yourself first. I know we can have other argument, but it may fall under a different category of liability. Because Bolton and Stone can be applicable in negligence also. For discussion purpose. Of course, Bolton and Stone, the lady was not able to claim in any manner. Negligence also not, and also public nuisance also not. But here is distinguishable, right? Rylance and Fletcher, pollen and seeds now, under Rylance and Fletcher, whether seeds and pollen from wildflower meadow escaping into neighboring land give rise to a strict liability under Rylance. Rylance imposes strict liability for non-natural use leading to escape of dangerous things causing foreseeable damage. Students can add, okay, the foreseeable damage part makes Rylance fault liability, and then you put a bracket, you can highlight Cambridge Waterworks against Eastern Counties Ladder. Students can add that part. As usual, I mentioned just now, you can add it, right? Post-transco, extraordinary and unusual use for non-natural use. So is it extraordinary and unusual use? Application. While the pollen and seeds cause wheat spread and hay fever, the meadow garden may be considered a natural or expected use in a public park please take note, whenever something naturally coming out of the land, it might not be actionable under violence. Something like thistle seeds, it is not actionable. So Giles and Walker will be an authority, good authority for you to cite. It must be something that is brought to the land, not naturally grow on the land. Thistle's naturally there. You are not growing thistle. The same thing, we need to find out whether this weed spread, okay, is natural on the land. It's not something unnatural in that sense. So given the natural growth and environment intent of the meadow, courts are unlikely to consider the council's non-natural. Also, personal injury is generally not compensable, okay, under violence and fracture. So likely to succeed, chances are very slim, right? That's your conclusion you can make. Finally, we get into negligence. Is there a trespass? I don't think so. Over here, I don't see any on that matter. Alfie, Two Rivers Council. Whether the council owed and breached a duty of care to Alfie by failing to ensure safe passage on public pavement where he tripped and fell. Old man. Right? Sometimes we must refer to, the Woolwich Towns case. I can't remember the blind man case. Under breach of duty of care. What is a common background of the people walking around there, So you can use those cases where, London Haley against London Electricity Board. That's a good case to cite where a blind man was tripped and fell, when the Electricity Board did not put a clear sign or ensure that people do not pass that way, especially blind people, where that town consists of a lot of blind people. Yeah. So same thing here, similar on the negligence part of it. Negligence, in principle, requires a duty of care, breach, causation, and damage. Occupiers or public authorities must take reasonable steps to ensure the publics are safe. The council allowed or failed to prevent buggies from obstructing the walkway. So a foreseeable risk arises where elderly pedestrians like Alfie are prone to tripping. So there may be a breach of if no sign, staff, or design provisions were used to ensure clear pathway. So these are basically your viewpoint, how you apply and discuss and tell them. So nothing to do with law, but the application must be based on the facts and your way of analyzing them. So that will give you a good grade of marks. Unless you want to argue, then that will be much better. So the foreseeability of injury, especially in setting used by elderly individuals, supports Alfie's case. So fractured ankle is a foreseeable and compensable harm. Hence, it's not too remote, should be able to claim. Finally, students can get into a quick discussion on defenses and remedy. Yes, coming to nuisance is not a good defense. Planning permission is not an automatic shield, according to Coventry and Lawrence. Statutory authority would need to be proven and specifically authorize the nuisance. Specifically, statutory authority must have that provision to say that it may affect the neighborhood, hence the authority will not be responsible. But regulations will be made to strengthen or to make things better, right? Finally, remedies injunction may be limited due to the public benefit of the park. Okay, we call quiet time injunction or limited injunction, as in Canaway and Thompson, all right? Do not forget the case that you've learned. You can cite it here. Damages are preferable, particularly property damage to sinks and injury to Alfie. Question involves balancing communal benefit against individual rights. While parks promote social good, nuisance and negligence law ensure that such benefits do not unjustifiably impair private interests. So remedy should reflect this balance, basically. So, hence, okay, I believe that with these few years of captions, okay, with the authorities that we have intertwined ourselves to the new questions, we can use whatever earlier authority discussion. What is important is the flow of the discussion is important. It's not about what authorities that you're putting in or how many authorities, but the authority that you are putting in with principle Okay, so long that you justify and rightfully discuss, that's good enough already. Sometimes students always tend to ask, should I put this case? Should I put? It's not about inserting a case. It's whether you are citing it in accordingly into the discussion purposes. Then you are there, not an issue, right? If not, it goes into a, B, what we call this, a third class or second class lower only. Second class upper is important for us in LLB, University of London. Okay, having said that, I will straight away continue with the third part. That is, there is no new authorities here. I think there's nothing. I checked. There is no recent authorities. Recent mean very recent authorities on nuisance and Rylance and Fletcher so far. Okay. Okay. Right. Do you have any further things to ask from the topics that we have done? Nuisance and Rylance and Fletcher. If no, or not yet, let's move on to the next area of discussion, that is on pure economic loss and negligent misstatement. Hey, wait a minute. I think you have opened the wrong document. Hmm. Okay, for pure economy loss and negligent misstatement, this is an area where not many students prefer to answer. Simply because it has a lot of development, and at the same time, okay, it's not a favorite area of many students compared to the normal negligence and psychiatric illness. However, the examiners, okay, are prone to ask, okay, students on these areas, but it depended upon how the examiners are drafting the question. And one such thing that when you look into the trend of the past year's questions, right, of this particular area, it is mixed. Sometimes the examiner asks a general question of pure economic loss, which also cover negligent misstatement. And also a very specific type of question which relates to negligent misstatement alone, which is part of pure economic loss anyway. Okay, but specific. There are quite a number of circumstances, okay, that you can see. It can be a mix. Either they ask you essay or even problem. So there is no kind of a standard pattern in this area under negligence. So, and not in all circumstances or in all sittings, okay, examiners, okay, are testing the students, right? Except for maybe for recent situation, the examiner may ask. All right. So not in all years, I would say. Or sometimes zone A, yes, zone B, not. Okay. So due to that, some students prefer to concentrate more on psychiatric illness rather than, right, negligent misstatement. Anyway, okay, as part of our obligation, we are going to set our footing to look into, run through quickly on these two areas, okay, before we get into our final, that is the article part A, the one I need to focus to share some of my knowledge and approach to every one of you. Of course, no doubt you have done it extensively during your sessions, okay, class sessions. And during revision, I will run through it, okay, just for the refresher purposes. Yeah. Right. Examination paper May 2022, Zone A, essay. The common law's prejudice against recovery for economic loss should be seen as a general reluctance. Should be seen as a general reluctance to permit recovery rather than a hard and fast doctrinal rule, according to David Howard. So as a general remarks, this is discussed. As a general remarks, this wide essay, this is a wide essay question. It's a pure economic loss. economic loss as a whole. General remarks, this wide essay question invites the candidates to discuss the duty of care for recovery for pure or economic loss in policy terms. It is not directed specifically of a duty of care for acts for negligent misstatement, but leaves open the opportunity to choose either as a focus. So now, when it comes to essay questions, some of the most relevant authorities the examiners always expect students to use, right? And I've actually expanded it. These are the authorities examiners expect the students to have a good understanding, and it depends on the approach taken in answering either the line of cases beginning with Kettle and Stockton, which is good for you to start with Kettle and Stockton Waterworks, and culminating in Murphy and Brentwood. Okay, so Kettle and Stockton Waterworks, as far as the facts is concerned, right? Defendant who laid a pipe under the land belonging to a certain Mr. Knight were under a statutory duty to keep the pipe in good repair. A road ran through Mr. Knight's land, which made it difficult for him to get easily from one side to the other. So he contracted with plaintiff, Mr. Kettle, to have a tunnel dug underneath the road. Mr. Kettle agreed to do this for a fixed price, but after he had started the work, he noticed that the land was becoming hard to excavate because it was waterlogged. So he realized that the defendant's pipe was leaking and contacted them about this, but they negligently failed to repair it. Result of this negligence, Mr. Kettle lost profit on his contract, so he sought to recover this from the defendant. So Justice Blackmun said, look at what Justice Blackmun said, that Mr. Kettle could not sue in his own name for damage that had been done to land belonging to Mr. Knight. In other words, because Mr. Kettle had no proprietary interest in the damaged land, so he had no cause of action. In modern terms, we should say that Mr. Kettle's loss was purely economic. Even though you don't have a proprietary interest, you can sue someone successfully provided you suffer a property damage or personal injury, not for pure economic loss. So if the courts allow, then the policy, right, is defeated because we do not want to have floodgates of litigation, right? It becomes exponential in nature if you allow such a claim to occur. So this is the classic authority, right, on the issue of why the courts did not allow for floodgate of so pure economic loss due to floodgate of litigation. But the structure was not clear, right, until we are looking into the Valor and also, I think, Spartan Steel. These are the cases that we will be looking at to understand it further. But let's talk about Kettle first. The Stockton water case then established that the claimant could not recover economic loss resulting from damage to property in which he or she only had a contractual interest. So since this is an essay question, a bit of notation that I need to cite for students to take note of, okay, for analysis purposes. I read, note, this case encapsulates the problem which the courts have experienced with economic loss. The objection may be technical and against the merits, but it has always succeeded partly because of the floodgates argument and partly because of the realization that foreseeability is not by itself a sufficient limitation on the range of potential claimant. If Mr. Kettle could sue, could his workers who were temporarily laid off also claim? What about local shopkeepers, pub owners who would have taken the less money while the workers were laid off? All these things are part and parcel of the chain event. It's chain effect, they call it. So that is one of the reasons why the court, okay, put a stop shot on all these kind of things, not to allow such a claim to occur in the court of law that flood the litigation in the courts. Yeah. The point was tested, however, again, in Valor. This is about the when, there was an outbreak of the virus from a research center and affected cattle in a farmyard, right? And that has caused the animals had to be slaughtered and buried, not to be sold in the market. So the auctioneers, who are the middlemen, suffered income loss, right? Because they couldn't get the cattle and sell it into the market to be butchered, okay? So now, are they the owner? No. The suers are the owner. They are just middlemen. On papers, they take the goods and then they sell it in the market and then they pay the money to the owners of the cattle. So that was an issue, right, in this particular case. So the policy dictated here. Yeah. policy dictated that the line must be drawn somewhere, otherwise all of these traders would be able to claim compensation. This policy of avoiding wide and disproportionate liability was subsequently confirmed in Spartan Steel. Spartan Steel is very important, especially if you want to do essay question on pure economic laws. The judgment of Lord Denning is important. Please take note. Judgment of Lord Denning is important. And the categories of losses been divided or explained by Lord Denning will become very important so that we know which claims are recoverable and which claims are not recoverable. So Spartan Steel is the what we call the pilot case for that. Yeah? What I'm trying to highlight here is the more modern authority. Conakry against Network Rail Infrastructure, where the defendant damaged Network Rail's track, which has led to the interruption of rail services. That has caused some losses for others. So this is a test case. I'm going to the second point. In a test case, Network Rail sought to recover compensation from the defendants for the damage to the track, but also compensation paid out to the various TOCs during the period the lines were closed as a consequential economic loss. Defendant argued that consequential losses should be confined to the cost of repairs and loss directly attributable to network, not others, right, where they have to compensate in that sense. So it was a common ground that if the TOC had brought a claim in their own right, then it would have been dismissed on the basis of Stockton Waterworks because they do not have a proprietary interest again. So, but Court of Appeal prepared to allow Network Rail's claim on the basis that they had suffered property loss and the issue of recovery or compensation payment was one of the scope of duty and remoteness of damage. So now there's a bit of a leeway given in this case in 2012, is it? All right, on that. Not too narrow, but a bit of a leeway given because of the relationship that you could see between Network Rail and TOCs. Yeah? Right. So in this regard, we are trying to circumvent Stockton and also move away slightly from Spartan Steel. Now, that is on the part where you're talking about when do you have a proprietary interest or not, the argument of it. The issue of proprietary interest, being the owner or not, okay, depending upon a different side of circumstances where, when you're purchasing a property. Murphy and Brentwood is another case, right, where the court said that, okay, when you're buying a house, right, and when you're buying a house, then of course, okay, you are the owner of the house but not yet. But new house, you are whatever losses you suffer as a result of the damage done to the house, which is newly built, it should not be claimable under, okay, tort of negligence because you may fail, okay, you may fail because there is no duty of care for pure economic loss because those losses are considered to be pure economic loss. A bit of a variation made by Lord Breach, okay, by arguing about what is called complex structure theory, all right, in relation to defective building, but this remains just a discussion. So students can, all right, may want to read this further before trying to analyze and see, okay, how we can circumnavigate the idea of pure economic loss when it comes to defective property. So because the question is quite varied, it's a very general question. So we have to tap different segment of pure economic loss. Earlier was a contractual interest kind of situation, right? Then this one is more of a buying of a property or building a property, right? And then we are going into another popular line of discussion that is under negligent misstatement. Okay, the inception of the allowance to claim was made, okay, prominently in the House of Lords decision, especially by Lord Reid in the case of, okay, Hadley-Burn and Heller. I believe every one of you, right, can still, okay, reflect this particular case where a clear recovery, okay, was, okay, they then allowed, okay, based on the law in itself, even though, okay, in the decision, they did not allow due to disclaimer, but that is an opening of the, okay, room for claimants, okay, who does not have any, okay, what do you call it? So-called, we don't say proprietary interest, but you are claiming the losses of an investment due to the negligently made statement by the bank in itself, okay, who's a third party. So the Lordship noted that statements may be repeated and then relied on by an unlimited people. But then again, okay, if there is a special relationship uh, if there is a special relationship between the claimant and the defendant involving a very important notion which is called assumption of responsibility. Okay. And based on this assumption of responsibility, you can show proof that the claimant relied on that statement, then you should be able to claim for the losses that you have suffered, even though the losses are considered to be a pure economic loss, right? So Halliburton has taken a clear, okay, opening, a ice-breaking case in that sense, I would say, right? To allow a claim when someone is making a statement negligently, okay, under the law of tort. And from the line of authorities from Halliburton, okay, there were many other cases come into the court of law to decide as to whether how this assumption of responsibility test should be observed when it comes to negligently made statement, right? Such as the case of Mutual Life and Abbott. Students may have read it, okay, gone through your lecture, right? Esso Petroleum and Marden, Smith and Eric Bush, all those cases seems to have given some ideas on how the special relationship can be, right, observed and decided accordingly. But the test in itself is not getting a very clear, okay, guide observation. No courts have actually explored the test to put it into a proper and clear structure. The test is developed, which is a good test, but how to structure it operationally was not, okay, could not be seen from the line of cases after Halliburton and Heller. But Caparo gave some limelight on that. Caparo in 1990 gave some limelight. Yet Caparo, the decision, although the same decision made by the courts, by the judges, but the judges' reasoning, okay, or the way that they structure the test, okay, differed from one to another, particularly Lord Breach and Lord Oliver. Please take note, huh? Please go and read Lord Breach, how he analyzed, okay, pure economic loss, and as compared to what Lord Oliver has said about the test for pure economic loss. Well, Lord Breach went back to the normal notion of Donoghue and Stevenson. Even though this is a pure economic loss case, but Lord Breach discussed about the test of possibility and proximity and whether it's fair, just, reasonable, and to impose a duty of care for negligently made statement. Whereas in Lord Oliver, okay, explored assumption of responsibility. So which test to be used? In both ways, the decisions were the same. The decisions were the same. Okay, but how do we recognize the test? In which circumstances we need to use Lord Bridges test, and in which circumstances we should use, okay, Halliburton's test, right? Because in Caparo itself, both tests been used by two judges distinctly, all right? So let's look into what Lord Bridge has said here. Possibility of damage, necessary ingredients in any situation giving rise to duty of care that should exist between the party owing the duty, which was characterized as proximity or neighborhood, and whether it's fair, just, reasonable to impose a duty of care. In this instant, Lord Breach, okay, brought in the auditor's report that has been sent out as a circular in that case. He said we need to look into various factors in the auditor's report in a company situation, how the report's been distributed or disseminated to the shareholders, directors, outsiders, possible investors. So is it foreseeable? We need to look into whether there is a clear possibility of damage or not when you make out a statement. All right. And the audience that there, those are going to, and what is the purpose of that auditor statement, or rather the auditor's report they call, okay, or prospectus, sometimes they call prospectus also. Is it in the form of a general circular? So the reaching out to the audience, okay, is it something that has been intended? What is the proximity level? Who are the class of people you are intending to know? Purpose and the class of people you are intending to know. From there only we can decide as to whether it's fair to impose a duty of care. Whereas Lord Oliver looked into the ambit of assumption of responsibility. Again, he looked into the purpose. Right? Assumption of responsibility comes with a notion of, do you assume a responsibility? Mean, what is the purpose of this document? Who are the class of people that you want to reach? So even though, okay, the perspectives that they are observing are one judge is from Donegal and Stevenson and the other judge from Halliburton, that has created a confusion that what test to be used today. Are you using foreseeability test or are we going to use assumption of responsibility test? So that is one of the reasons why a lot of reading required in order to answer the test questions for essay, especially if particularly concentrating on negligent misstatement. Then a lot of reading required. Because there were a line of authorities here you can see after Caparo was decided, such as White and Jones, okay, Henderson and Merritt Syndicate, okay, we call, what do you call, Williams and Natural, okay, Life, Food, Limited or something like that. Williams case they call it. All right. And there's one more case I'm trying to recall also. So those are the cases seems to have expanded. Okay. The negligent misstatement that includes negligent advice, negligent services, and so forth. Why? Because of the overlap in terms of use of foreseeability test and also assumption of responsibility. So which test is the best to be used today? It is merely a slogan according to Gilliker today. Yeah. So I'm just highlighting those are the issues that a reason, especially after 1990. Anyway, Caparo was considered by the House of Lords, okay, in Customs and Excise Commissioners, right, in 2006. Okay, I believe everyone knows pertaining to this case. Lord Bingham made a determining point that I incline to agree with the view that the incremental test is of little value, as the test in itself is only helpful when used in a combination with a test or principle which identify the legally significant features of a situation. So the closer facts of the case in issue of those of a case in which duty of care has been held exist, the readier the court will be the approach of Justice Brennan adopted in Caparo to find that there has been an assumption of responsibility of proximity and policy conditions of the threefold test are satisfied. The converse is also the truth. So they said whether you use Caparo's test or you use assumption of responsibility test, okay, it doesn't make any difference in our decision-making process. It's just a matter of how convenient we are using it. That's according to Lord Breach here. So different judgment came into the picture, right? And we are also having a extra jurisdictional authority to analyze, okay, this point. I'm adding more and more because this is not exactly you have to cite everything, but knowing the fact that it's a mixed question, but I just, in this year, I just wanted to add so that it will be useful for the reflection of other questions. Yeah. Students can also look into Sullivan and Moody, right? The idea of proximity. Now, coming to English authorities, as I said just now, White and Jones must be used as relevance for negligent misstatement essay question. White and Jones, Spring Guardian Assurance, right? And White and Jones expanded, okay, the assumption of responsibility test to include negligently made services. Okay, negligently made services. And also can be seen, all right, Spring against Guardian Assurance on the fiduciary relationship again, on the business third-party relationship with reliance happened by the third party. And then moving to Gorham, if you can see, the principle in White and Jones also extend to financial advisors, advice given, right? That was highlighted in the case of Gorham against BT. Standard Life sold Mr. Gorham the personal pension but failed to advise him. Failed to advise. So can you be held liable under Hadley-Burn principle or not? The court said that there is a possibility here. So Hadley-Burn, which have actually started from a statement, expanded to various, okay, aspects. That include that include what we call physical support kind of training, like, remember Woodlands, Swimming Teachers Association. Yeah, Woodlands against Swimming Teachers Association, where, okay, the court used assumption of responsibility test. So there is a lot of overlaps of usage of the test today, right, in various kind of situation, whether it's an act, it's a service, it's a statement, it's an advice. The academician found that the judges are using the test interchangeably already. Okay. Okay, we have the case of Patchett also for your observation, where trade association had made a statement on its website. So do you assume responsibility when you make statement of the website and it becomes wrong? Okay, it becomes wrong. So how far the website can actually affect the people out, and is it, okay, meant to, focus on particular group of people or anyone? So are they responsible if the statement in their website is misleading? Yeah, and so people are suffering losses out of that. Patchett's case will be relevant there. In 2015, we had a case of Sabri against Company South. All these are flow of discussion of the development on the Halliburton and Heller, where the registrar of company was found to have assumed responsibility to company where entering a winding up order on the company register. This is a bit more of a narrowed information from the registrar of company. It's not a general website information. All right. More recently, Playboy Club London against Banker Nasional, a bank was found not to owe a duty of care to a casino, despite the fact that it had provided a negligent bank reference, which the casino had relied upon in accepting gamblers' check. Here, to protect the gambler's privacy, the casino had acted through an agent Burlington. So there is a relationship that cannot be assumed because of the third party, that is the agent, is involved. But there is a possibility if the proximity level is close, right? Special relationship can be established depending on the facts again. That is Playboy Club. And other cases, of course, I did mention about White and Jones already, Spartan Steel. All these are additional observation, okay, on the part when we are talking about essay question. So a reading is required if at all you want to do an essay question. But the general ambit that I'm highlighting to you, basically to tell you that there are quite a number of variants in approaching the test for negligent misstatement question for the claim of pure economic loss. So there is some level of flow based on a lot of information authorities I have. I've highlighted the flow of how you can actually develop the segments of your answer. Okay. There's a critical analysis debate brief, brief points been mentioned over here. 2022, let me go into it before we take a break. Let me get into 2022. This is a question on essay also. Okay, there is a tendency which has been remarked upon many judges for phrases like proximate, fair, just, and reasonable, an assumption of responsibility to be used as slogans rather than practical guides to whether a duty of care should exist or not. So, yes, of course, again, this is particularly concentrated. So more of the above authority can be used in this particular question, right? Look at the caption on the general remark, this part only I'm highlighting in italic already. The question refers to the tendency of judges to use slogans rather than practical guides in determining whether a duty of care exists in a case of negligent misstatement. So negligent misstatement arises where a party negligently provides inaccurate or misleading information, resulting in economic loss to the recipient. This essay will first examine the policy consideration that underpin the duty of care for recovery of pure economic loss before discussing the application of the legal concept of proximate, fair, just, and reasonable, and assumption of responsibility to determine whether a duty of care exists. So basically, many students be asking me, even throughout the year, sir, how am I going to answer an exam question? I say it doesn't matter, whichever test you use, so long that you are using them properly based on the given circumstance and precedent. That's all. So you need to read a lot of cases in order for you to have a good digestion on how to apply them. Esso Petroleum Marden is a case to discuss for this question. Smith Eric Bush, I've given a brief facts of that. Caparo, you know already. White and Jones, Spring Guardian Assurance, Henderson Marriott Syndicate, all these are authorities for essay question. Right. I don't know why it's run off, but let me October, I'm not going to deal with it, okay, but for your reading purposes, a guide 2024. 2023, sorry, 2022, 2023. Just to tell you that in 2023, Zone B, there was an SK question again. Describe and analyze citing the relevant case law and approach of the English court to the tort of negligence where economic loss has been caused by the provision of information. Right? They didn't directly say negligent misstatement, but provision of information. So this is the question about negligent misstatement. There was an essay question on this. Right? Again, I've highlighted Halliburton, Caparo, Esso Petroleum, Spring Guardian Assurance as authorities, William Natural Life. Okay. And then May 2023, Zone A, also a question on this topic. Describe and analyze, citing relevant case, the approach of English law, English court to the tort of negligence in cases where economic loss was caused by provision of defective building, a very specific area. It's not about negligent misstatement, but it's a development from ends. So because of the variation and gravity of information, students tend to be very worried whether to answer this question. They do not want to go wrong, off track. Student, the moment they see economic loss, they tend to write everything about it. No, it's wrong. Depends on the question. This one is about defective buildings only. All right, where you have additional cases like Simaan and Pilkington, DMNF estates, okay? Quite different from the negligent misstatement cases, right? Murphy and Brentwood, and so forth, right? So that is to highlight to you 2022 and 2023 development. After the break, I just need to check whether 2024, just to reconfirm whether in 2024, do we have, did I put any question on that? That question, if there is, then we are going to highlight this or discuss about this. Sorry. 2024, yes. There is. Right. There is. So I will we will look into the trend of 2024 after our second break. It's already 11:43. So once we come back from the break at 11:50, okay, I will run through 2024, okay, as fast as possible. Once you have done with that, then we will get into the article straight away. That is compulsory area. All right. Public bodies, I've sent you the documents. I will only focus 2024, no question. So I will briefly run through 22 and 23 only for public bodies. Yeah. If we have sufficient time, but after we finish, okay, quickly on negligent misstatement or pure economic loss, we will straight away go into Article A so that reflection will be done on what you need to do. And feel free after this revision, if you have any questions that I've highlighted there with the guideline answered by you, send it to me. All right, I will be able to give you some comments based on the hypothetical question. There's no actual question, but I have actually designed some possible way that the examiner may ask from each and every part of the Article A. So that is to give us some idea, our direction on the article in itself based on the issue pertaining to Lot B rules. Right. So we'll take a break now for about 5 to 7 minutes. I hope we should be back at 11:50. Hi everyone, welcome back. Okay, let's continue with from where we stopped first, before we get into the next topic. I was at 2024 questions on pure economic loss and negligent misstatement. Okay. So exam paper May, Zone A, essay again. Ordinarily, pure economic loss is simply not important enough to justify the law imposing general duties on people not to cause other people to suffer that kind of loss. So the wording in itself shows clearly that this is not focusing on negligent misstatement, but negligent misstatement will be important or substantial enough for you to answer anyway. No, mostly students will do that way, right? Because of the development is development is continuing in that area. And the statement made by Nicholas McBride, very important author, okay, of a textbook, analyzed a lot of things, okay, on every part of the, tort law development, okay, in his book. So this question provides an open-ended opportunity for candidates to discuss the policy issues behind pure economic loss. The cases that we are actually highlighted, that have actually highlighted by the examiners: Spartan Steel Ends for buildings, Murphy; negligent misstatement, Hadliban, Caparo; Commissioner of Customs, Excise, and Barclays Bank. So students also can go back to other aspects like, Kettleton against Stockton, Kettle against Stockton, other earlier cases we mentioned, because it starts and ended in Spartan Steel, you see, on the pure economic loss side. This is a question which many marks were average, but few were very good. Many just stated that the policy reasons generally and uncritically, or cited cases without explanation or justification. So some attempted to cover too much without adequate detail. Not necessary to cover too much, but make sure whatever coverage you make has got necessary detail. And we know that a lot of arguments, okay, from the 19th century origins to present illustrating the line of arguments with appropriate cases that is required. A lot of critical analysis and discussion required for this question. Examiner's expectation is high for these kind of questions. Yeah. So there's a student extract for you to read. I'm skipping that part. Answer outline that I'm suggesting here. Always, okay, look into the statement in itself. This question requires examination of the tort of negligence in relation to pure economic loss and an evaluation of Nicholas McBride's assertion, where pure economic loss, which is a financial harm that does not arise from a physical injury or property damage, has been treated with caution by the courts. Central issue is whether it's appropriate for the law of negligence to impose a duty of care to prevent purely financial losses. In evaluating this, it is necessary to explore the rationale behind the general rule of non-recovery, examine key exceptions, and assess the theoretical and practical implication for tort law. Okay, so by definition, students can use any definitions that you want. Okay, it is already been given to you. What is a policy recognition? Right, number one, floodgate argument. Number two, contractual allocation. Okay, if no contractual allocation, the courts are a bit more, okay, cautious, unless you want to argue through the back door, they call, okay. Autonomy and reliance, okay, in contrast to personal injury or property damage, pure economic loss is often result from voluntary commercial risk-taking, weakening the case for tort protection. So you don't have much autonomy, right, and lack in reliance objectively analyzed for pure economic loss. So the articulation can start from Spartan Steel, okay, against Martin. It's about the loss of profits due to negligent power cut case, right? So academic commentary, I'm putting it here, academic commentary strongly supports this cautious approach by Lord Denning. Okay. McBride and Bagshaw argue that recognizing a gender duty for pure economic loss would create legal fiction of social responsibility that the law of tort traditionally avoided because it becomes, okay, right, floodgate. Professor Jane Stapleton also critiqued economic loss as inherently distributive rather than corrective in nature, better suited to legislative or contractual remedy. However, come to negligent misstatement, the expansion could have been seen already. Okay, there again. So that is where the expansion that we can analyze from negligent misstatement, Hadley-Burn and Heller. Then you go into the next point where you are talking about the negligent services, right? Through the case of White and Jones, solicitor's liability, delayed in will writing. Defective premises, as far as we are concerned, the categorization was made wrong in Ants and Merton London Borough Council, eventually, right, overruled in the case of Murphy and Brandwood. Okay. Here, academic view, Professor Gilliker, I'm highlighting here. Observe that Murphy reaffirms the centrality of damage in negligence and resists the temptation to convert tort into general warranty of quality, which should remain within the domain of contract law or under the statute. Okay, National Housing Building Schemes, I think 1985. So that is to limit claims under tort law. Negligent by public authorities, yes, customs and excise against Barclays Bank. Okay, although no duty was found in this case, House of Lords clarified that assumption of responsibility remains central to determining when economic loss is recoverable, reaffirming the narrowness of exceptions. Right? So courts suddenly seem to have expanded it, and now courts are having ultimate problem how to narrow things in each and every part that they have actually expanded. Expansion already done. Okay. Extension already done. They call extended principle already done under Hadley-Burn and Heller. So students also can cite Caparo and tripartite test that has been developed, okay, by Lord Breach. And then only you can actually get into some critiques and justification. It's an essay question. Open texture on how you want to answer. Different student will have different readings from the different perspective. That's always can be used to argue. So just as general framework, I have actually highlighted here on the focus of the question so that you are not going off track from what examiner is trying to highlight on this particular aspect of law. Eventually, student can get into conclusion. Yeah, that is 2024. In Zone B, also examiners tested again, but this time is very much concentrated on assumption of responsibility rather than the general pure economic loss. It's not about negligent misstatement also. Oh, yes, that is, sorry, make of the statement, yeah, to have assumed responsibility, right? Assumption of responsibility. So coming to assumption of responsibility, the added cases definitely will be, Smith, Eric Bush, Henderson and Merritt Syndicate, Williams Natural Life Health, Merritt and Barb, Burgess and LeJohn, and others if you want to, okay? Because it is focused on one particular segment that is negligent misstatement. So students can, this is a student extract, right? And I'm not going into that. Students can read, you can read. So on answer outline for this kind of question, okay, which I already earlier mentioned already, a bit of expansion that I wanted to give, especially on the academic interest, right? One is the general genesis of assumption of responsibility, all right? It is about the significant development that occurred, especially on the negligent misstatement cases. Interpretation of assumption, yes, how the courts are actually interpret them, okay, on the voluntary assumption of responsibility, whether you have personally assumed, objectively analyzed, or subjectively. So the court will always look into the objective analysis that can be seen from the case of customs and excise against Barclays Bank. What about the complement, or how to complement, okay, between the test of Caparo and Hadley, which I did mention just now, the issue in Caparo as a result of the both tests being digested by the courts based on two judges, Lord Oliver and Lord Breach, from the test of Donegan and Stevenson, and also, right, Hadley, Burn, and Heller, right? The framework in Caparo, leading framework is, of course, Lord Breach's, okay, foreseeability, proximity, the incremental approach we call, right? Academic insight. Lord Bingham in custom viewed these tests as complementary. Gilliker similarly argues the assumption of responsibility functions best as a method of identifying proximity and foreseeability in Caparo terms, especially when contractual privity is absent. What about judicial and scholarly commentary? This is also another analysis we can make, okay, digested from scholars, okay, like Stapleton criticizes the doctrine as a part of fragmented pockets approach that risks inconsistency. She argues for a more transparent analysis of policy factors, particularly where assumption is used to stretch liability boundaries. So that is what Stapleton tried to say. Okay, looking into variations in the approach given by the courts, right, and the judgments. Right? For pure economic laws is fine. What Lord Denning has said is clear-cut. But comes to other parts, that negligent misstatement, that's where the laws, okay, seems to be moving into various, okay, dimensions and directions. Right? Nolan, on the other hand, 2017, supports a rights-based framework. So what Nolan argued was that assumption of responsibility recognizes obligations that arise from voluntary undertaking and relational context. This view suggests that the doctrine protects reclaimants' reasonable reliance while preserving autonomy for defendants. So Nolan preferred to see assumption responsibility basing on voluntary undertaking and relational context. Yes, right? But the only problem that we are still facing is the expansion is not about the test in itself. Expansion is that assumption of responsibility has been accepted in various kind of situation, not only on statement. It has been accepted in negligent advice. It has been accepted in negligent services, and also now negligent acts. So what does it make a difference between these and the three-part approach given by Lord Bridge? That is where we are having a problem. Okay, so that is my viewpoint of how, okay, I am looking at Nolan's right-based framework. So which means what he's trying to say here is, when we use assumption of responsibility, it must be based on this. Yes, it is understood. But whether you are using incremental or this, what happens to the distinction where we talk about X and other parts? Stapleton, 2002, in contrast, calls for assumption to be reconceptualized. This is good. Reconceptualized, not as a distinct doctrine, but a shorthand for policy determination that it is appropriate to impose a duty. Her analysis influenced Lord Mann's approach in customs, where he analyzed indeterminacy, alternative remedies, and proximity. So basically, these are the comments made by them. So the expansion, you can see from Smith, Eric Bush, and if you can see Merritt and Barb and Burgess and Adjournment, you could see expansion of assumption of responsibility there. Like Burgess and Adjournment 2016, a professional architect who provided gratuitous advice was found to have assumed responsibility. Gratuitous advice. So this is a determining point to say that, yes, if you give advice, the test that we are using is assumption of responsibility test. We don't use Caparo's three-part test already. In the beginning, it was not mentioned in Halliburton and Haller. Halliburton and Haller only talks about statement, not advice. Policy concern, the flexibility of Caparo and overexpansion risk that they are talking about. So that is what I'm briefly highlighting on this area. Now, quickly, I run through the recent cases. 2024, that shows that this year probably is relevant because there's a recent authority on that. Armstead Royal against Sun Alliance, UK Supreme Court. A driver hired a vehicle from a car rental company. Due to the negligence of another driver, the car was damaged. Under the hire contract, Armstead was liable for loss of rental income during the repair period. She sued the negligence party insurer to recover the contractual liability, where Supreme Court held that Ms. Armstead could recover the contractual liability as economic loss, provided it was foreseeable and not too remote. Court rejected the argument that such damages were irrecoverable simply because they were pure economic loss. So this case expands the scope of recoverable economic loss where the contractual obligation is a foreseeable consequence of negligence, indicating growing flexibility in approaching economic loss in tort. So again, there is another line of expansion can be seen from the decision of UK Supreme Court. 2024, Tyndall against Chief Constable of Thames Valley. Police officers came upon black ice on a public road. This is on public body now. Again, it's about pure economic loss also. And after briefly stopping traffic, left the scene without taking steps to warn motorists. Shortly after, a driver skidded and died. The widow sued the police in negligence, arguing that they had assumed responsibility or interfered with others' ability to prevent harm. Even though this is not a pure criminal, it's not really a pure criminal, but look at it, they use the test of assumed responsibility, which usually used under pure economic loss or under negligent misstatement. So the Supreme Court recognized the interference principle that liability may arise where a party prevents others from acting to avoid harm. However, the court found that the police had not sufficiently interfered, nor had they assumed responsibility toward road users. So what is the significance of this case? This is a rare Supreme Court discussion of pure omission liability. It confirms that assumption of responsibility must be clearly established and policy constraint like public service duties still weigh heavily against imposing liability. So there is a bit of a cluster of discussion. It's not a pure economic loss, but there again, the court used assumption of responsibility. So that shows very clearly the tests are being used interchangeably. No more how you derive your operations, your type of act or omission, right, which can fall under the three-part test and negligent misstatement under Hadley-Burn principle. Eventually, Hadley-Burn principle expanded. We don't say no to negligent services, negligent advice and everything. But then again, now it has also gone into negligent act and also reinstated by court in 2024. That means assumption of responsibility can also be used for on the normal Donaghy and Stevenson kind of ambit, they call. Okay, so that is, I would say the continuing confusion is continued until there must be some clear settings of how the laws are going to, or the tests are going to be used already. But I think courts are going everywhere. So the courts are, in a way, feels that assumption or responsibility is a test can be used, okay, across the board. Simple as that. Yeah. Even assumption of responsibility, okay, last year, if I'm not mistaken, I did mention when I was doing a contract law, it was even used in the case of Great Peace Shipping against, not Great Peace Shipping, in the remedy of remoteness of damage, okay, under Hadley and Baxendale, I mean, to recollect back, okay, the more recent authority, Achilles, yeah. They use assumption of responsibility in contract already. So the assumption of responsibility became a very popular test, okay, in various aspects nowadays. Yeah. Having said that, we are done, okay, with pure economic loss and negligent misstatement. Take a 1 minute breather, okay, then we will, let me get the notes ready and then we move on to our article. I'm giving myself about 1 hour for that article with you before we just run a quick run through with the public body and then we will, I will hand over to you for any further questions, yeah? I believe my counterpart, Mr. Kuchen, if I'm not mistaken, okay, he did he was dissecting with every one of you on the understanding of the article in itself during his session. If I'm not mistaken, this is what I received a feedback from him. He did, in a way, he did a summary for that. So just give me a couple of seconds. I'm trying to open the file. Yeah, I did about a 9-page summary on this area. And okay, what I will do today is just to get into each and every part to have this, what you call abstract proper, a summary proper, okay, on each and every one. Everyone read it already, so you know the details, or it's just a matter of reflecting back the details of it, okay? However, what are the importances attached to each and every part of the article, the article created or prepared by the authors? There were 3 authors there, actually, right? By Cave, House, and also J. House, C. House, and J. House evaluates whether former rugby players suffering from neurodegenerative diseases, NDD, caused by traumatic brain injuries, TBIs, can bring successful negligence claims against rugby governing bodies. The authors argue that legal avenues, if carefully framed, are increasingly viable due to 3 reasons here. Number one, evolving medical knowledge, i.e., diagnosis, okay, of TES and CTE. That's in that summary, all right? The medical terminology, unless one of you all here are medically, specialized, then I will be able to understand better, okay, about all these terminologies. I'm not a medical lawyer, but tort lawyer. But there again, okay, the medical terminologies are quite extensive in various ways, right? And growing recognition of institutional duties to manage sports-related risk. And thirdly, a legal precedents which accept regulatory omission liability. Regulatory omission. Omission itself is quite a very advanced concept, which can be, observed in many variations, I would say. If I'm not mistaken, when I was doing the article of omissions, about 5 or 6 variations can be seen on omissions. So this is quite detailed, the omission part of it, because it's not easy to sue someone successfully, okay, due to omission. And because one of the reason is because the other party is a public body. But there again, ignoring the public body, looking into other people, how are we going to engage ourselves successfully on claiming under omission? Because most of the time when you're talking about certain things, when it comes to, when it comes to football or cricket or rugby, for the matter, since we are talking about rugby here, yeah, there is always a bodily contact. You cannot avoid a bodily contact. And most of the time, the injuries sustained on the serious part will be the head. All right. But one thing you need to understand the difference between rugby and other games, like for example, football. More often than not, your injuries are prone to happen, okay, on the leg. Rugby, injuries prone to happen on the head. Cricket, injuries prone to happen. I'm not very sure if you don't wear the thing, or rather they call the helmet, then of course, okay, you can hit your eye or face, right? Different sports will have, like even the horse riding, right? You may suffer a backbone spinal injury, we call. But those sports, if you really look at those sports, football is about scoring a goal by bringing a ball. Your job is to ensure that you kick the ball and score the goal. In cricket, you need to ensure that you hit the ball and scoring a sixer. In rugby, you need to ensure that you hold the ball and cross the, okay, what we call the winning line. That is a purpose. But comes to boxing, the purpose is to hit the person. There is a difference. That is why very hard for us to draw a clear distinction or or rather try to follow boxing. Very hard for us to follow boxing because boxing in itself is a game that targeted at a person, not targeted at a goal post or whatever. So for that reason, it's very hard to, try to follow the trend of how the courts decide on boxing matches compared to rugby matches. However, authors are not saying that there is no possibility. There is always a possibility, but how are we going to understand, okay, that who is going to be responsible and how they can be responsible in this kind of set of circumstances? So from the introduction itself, okay, right, we need there is a question that we need to ask ourselves, that how recent development in medical science and tort jurisprudence have renewed the possibility of success in rugby-related neurodegenerative injury claims. How recent development in medical science and tort jurisprudence has renewed the possibility of success. So what is meant by how medical science, okay, or medical advances have shown that? Because in the olden days, okay, it is very difficult for us to identify whether the person is going to suffer any form of future diseases, because medical advances is not good enough to appreciate that a small hit to the head will eventually develop a disease for you, such as Parkinson or, what we call here, NDD or, NDD. But today, there can be a trace based on the injury sustained. A latent damage. Latent damage basically means a damage that has can only be seen after some number of years, like 10 or 15 years. You can discover the result of it, the consequence of it. In fact, Muhammad Ali is one of the person who's suffering from a Parkinson disease. Okay, he was suffering from Parkinson disease. That was, of course, as a result of the boxing injuries that he sustained on the head. But that was naturally a kind of a spot that you sustain on the head, face. That's a target, actually, as opposed to rugby. But head injuries in rugby is inevitable. Inevitable. You can't avoid. But when you suffer bleeding, then it's quick. Everyone can appreciate and understand. Plus a concussion during game. Yes, everyone could understand and appreciate. But there are many occasions these players do not suffer all this. A bit of a normal injury within the framework of the game, like in Sims against Lay Rugby Club. Yeah, normal injuries, tackle, and all these things can happen. Is it within the threshold that is allowed under the game or not? That is different. This one is, you can't see the injuries now, but later you discover. So medical advance, when we look into the guide, if at all, the examiner is asking about from the introduction perspective, medical advances such as Glasgow field of study, that is in your article, please refer to that, right? I can't go into that because this is a quick revision already, but just reflect back what you have read. I believe that every one of you read. Glasgow field of studies, Drake rugby biomarker studies now support in live diagnosis of TS, bridging the evidentiary gap that undermine past claims. Bridging the evidentiary gap. That means there is a way that you can actually identify. There is a bridging evidentiary gap already, right? That undermine the past claim, which means you can trace it, you can trail it back based on the modern technologies. That shows that judges were able, the doctors were able to tell that, look here, there is a cause for this result. It's your rugby. There is a cause. But we cannot say that it's 100% due to that, or 55 to 60% due to that. But it has contributed to your current disease that you're having. That is evidentially proven or can be shown through medical advances. Okay. Number two, second point, legal shift from individualized fault to institutional responsibility. You see, when you are having a game, okay, then I play a football and I tackle you and then I punch you, that is individualized problem. You can take an action under trespass to the person. Okay, trespass to the person. Or if the referee on the day tried to, control the game but were careless or ignored the position and that has caused some further injury due to the tackle made to the participant. So you can sue the referee for not being able to control the match properly. But we are not looking into that specific nature which the law already developed. We are looking into the institutional responsibility. And what do you mean by institutional responsibility? Because I remember, okay, I was, a judge, okay, way back 20 years ago in 2004, I think, 2005, I was a referee for karate in national competitions, right? For some years before I retired from the whole martial arts, okay? I remember, okay, from the time I became a martial artist, okay, representing my state in the competition, the rules were different. The rules were different. Sometimes, okay, they broke my nose. It is still ongoing things. You can still continue to fight. You can have a leg injury. Then later they come up with a full contact where you have to wear a mask. See, the rules kept on changing. As the rules kept on changing, are there any flaws in the rules set by the organization that has overlooked certain part of the rules that has caused such an injury and which is expanded over years? Because when something expanded and many people suffering these kind of injury, that means there is something wrong with the rules that you have changed or the rules that you did not implement. This is called the failure to implement such rules that has caused the losses. And 1% out of 100 is something that we cannot trace it based on the rule. But if there is an overexpansion of people who are suffering, then there's something wrong with the setting of the rules in the beginning itself. That is what we call the institutional responsibility. But of course, in Watson, there is nothing wrong with the rule because it's all about punching people. It's all about punching people. Watson against British Boxing Corporation. There is nothing. But there again, the moment someone is injured, where the medical care is ready enough to treat the patient or not. That's where in Watson the claimant was successful because the court held that the medical attention was not perfect enough, good enough to immediately treat the person who was injured. Nothing to do with the rules of the game. So we need to contrast that. So the academic support for viewing sports regulations as a site of public law accountability. So here the next point is, claims are reframed to focus on omission. Claims are reframed to focus on omission. Failure to implement known protocols. Because we cannot go into the action, whatever happened, because we cannot trace back which incident has caused the concussion later. Because games are such prone to happen, injury prone to occur. But more and more injury can easily occur if the rules are not set clearly. If you tighten the rule, then you see when karate organization, I'm reflecting this to show a difference. But I wouldn't know, all right? How you can always use your own opinions, to just because it's all about games. Yeah, International Karate Organization, World Karate Organization, Federation has actually changed the rule to say that, you can't touch the nose when you punch. You must wear a glove. Why? Because that will reduce the contact. Because if you don't do that, then more and more people get into contact injuries, then eventually later there is a latent damage. Then you have failed to observe such kind of protocols, you see. rather than prevention of injury. So you need to look at it on that broader side. So the reflection here is we need to acknowledge that regulatory bodies are no longer mere facilitators, but actors with affirmative safety obligations already. They are not facilitate. We are trying to facilitate by setting certain rules. No, you are an actor with affirmative safety obligation. Did you act well? Did you perform well in your setting of the standards of the rules that you have? So that is the first thing. So the other problem that, okay, the first problem that we face is statutory limitation. So because of the statute of limitation comes into the picture and the Limitation Act 1980, many people cannot claim. Too bad. Because most of the injuries can be discovered and became transparent easily after 3 years. Easily. So what are you going to do? You can't do anything. But there is a pressure, there is the what we call the serious, okay, observation need to be made because the sufferance of the people can be seen throughout. Even in psychiatric illness also, we have the same problem, no, post-traumatic stress disorder. Sometimes, okay, it happens after a few months. Sometimes it happens after a few years. So limitation may come in. So can we overcome this limitation period or not? So a summary of this statute of limitation, okay, is based on a key hurdle, is where the limitation which says a 3-year time limit for the date of knowledge of injury, okay? Since neurodegenerative symptoms often emerge long after retirement, claimants rely on judicial discretion under Section 33 to disapply limitation, all right, based on specific reasons. How are we going to implement this idea? How might limitation defenses under Limitation Act be overcome in claims for sports-related NDD? So if this can be an area to be asked for us, then we need to look into what the courts can do. Okay, courts can consider fairness to both parties, balancing exercise. Right? Can the courts take this more, okay, vigorously or more specifically, especially for rugby-related cases? Yeah. Date of knowledge, this is another thing. When you receive the knowledge, yeah, injury is there, but the knowledge can come only after a long delayed diagnosis, which may take years. It's not immediate. And to understand the ambit of causation, this is the reason why we need to shift the limitation period from the date of knowledge proper. Not the knowledge of injuries that generally you suffer, but knowledge proper. If you suffer concussion on the spot, it's different because things are there, ongoing. But people can start developing problems and diseases later than when the actual particular medical knowledge identified. Then from there, we take 3 years. So here, I think the authors, if I'm not mistaken, cited precedents such as Stubbings and Webb, KR against Brian Elin. Courts exercise discretion based on trauma evolving awareness or delay not being blameworthy. Okay, that is the second point. The reflection on this, courts may become increasingly sympathetic as media, science, and sport reveal long latent harms. The limitation defense also challenges the evidentiary burden, placing value on cumulative records like club data and televised match. A lot of work required to look back, okay, on all this. Normally very hard to prove because the records might not be available, data might not be, easily available, and so forth. Yeah, right. So that is number 2. But of course, okay, comparatively with those days, 1970s and 80s, where you don't have a proper retract back on all these materials. Sometimes what I'm talking is basically to let us analyze, so it will give us a feel of writing in the examination when you are pinpointing something, a bit of a point of view that I'm giving on that based on what could have been the timeline of what's happening throughout the 50 years that we can see, right? The 1970s, 80s. But if you look into today, 2025, I think we can always trace back many videos and many information, in the past 20 years already, because of the advancements of, all these social media platform, recording technologies, uh, we can see as old as 1970s, bit of a caption here, 80s. In the year 2000, and we have a lot of gadgets and things to, be able to, edit, analyze, okay, many previous, okay, videos or documents can always be scanned nowadays compared to those days, due to the advancement of, scanning technology and also telephone technology or handphone technology. So basically what I'm trying to say is, it's available now, evidentially, okay, records is better available to prove. So that is the first two parts. One is on the introduction and the other one is on the claimants. Now we are, sorry, limitation. The third one, okay, will be the claimants. Who are the possible claimants? That was highlighted, okay, by the author. Claimants include who? Retired amateur and professional players now diagnosed with NDDs like the terminology they use, CTE, Parkinson, and MND. These conditions often stem from repeated concussions and subconcussive event. So while participation in contact sports entails risk, such as one of the oldest case, where the case affirms, Cleghorn against Oldham, affirms that injury in serious sport can give rise to liability where duty of care is breached. It's available. You don't say no. So now the question that we have to ask ourselves, possibly asked by the examiner, is evaluate the type of injury suffered by rugby players and explain how the law of negligence applies notwithstanding the voluntary nature of their participation. How the law of negligence applies. Okay. So what we can analyze from the perspective of the claimants here will be, the type of injury, how the injuries are occurring. What is meant by TBI? Include concussion, or they call diffuse axonal injury, DAI, chronic traumatic encephalopathy, CTE, and later neurocognitive decline. So a bit of a knowledge from the article, if you can read and try to digest, where you can't refer to article anymore in the examination. So digest and remember, that will be good. And then we need to look into how this can be differed from one situation to another from the perspective of claimant, like voluntary participation. Is it a blanket consent to negligence? Not really. Okay, it's not a blanket consent to negligence. Yes, injury is prone to occur, but so long there is no negligence. If there is negligence, there is again chances for you to take action against the other person. That is Woolrich and Sumner, which recognizes acceptance risk, but in Watson allows claim where institutional safeguards fail. So you see, you are shifting. Okay, look here, never mind, injuries occurred. Probably because of the benchmark, I can't claim, or even I can claim, depending on the type of incident. But let's go beyond the claimant and look into the institutional safeguards. So as a claimant, I should be able to, understand that there is a voluntary participation, but if I fail here, I can still go further to the institutional safeguards. So the evolution from spotting risk to institutional omission realigns legal focus from individual actions to systematic failures. And there is an objective here to ensure the organization will continue to ensure that their regulation and rules are properly observed. What the author is trying to say here is, yes, they are doing a proper observation, but their far sight is very short. The rules been set with a very short far sight. And what author are trying to say that the regulators should, okay, look into a far-reach situation, which they won't do unless we are alerting them by bringing these issues on board. That's what author is trying to say. Author is trying to bring it forward. Now look here, we are already identifying these kind of matters and is spreading quite a number of cases. If we don't, okay, right, instigate this, I think regulators are not going to have a far-reaching kind of rules. They're going to have a short rules to implement to overcome their short problem, the shortcomings they call. So we need to realign them, spotting risks to institutional omissions. So because players may not be in a position to evaluate, somebody must instigate. That's where the author is trying to say. Long-term risk due to delayed symptom, onset, and evolving signs. Yeah. Then getting into selecting appropriate defendant. As we know, the governing bodies such as World Rugby or national unions are the most appropriate defendants due to their role in setting the framework of the rules, medical protocols, and player welfare standards. So claims against clubs or individual actors often fail due to lack of proximity. That is one challenge we see, lack of proximity, because player under the club, they have their own rules. Among players, they have their own legal duties. Coming to pitch with the referees, there is another frame of secular of proximity, right? Going into the national organization, one proximity. Going to world organization, another proximity. So the proximity issue will be there. Like, remember the case of Sutradhar. I think that's what I can remember. Okay, you can't impose a duty of care, right? For omission here, and then it caused some effect to some, okay, farmers in another part of the world, somewhere in Sri Lanka, if I'm not mistaken. All right, so too far, right? So that is are the most appropriate defendant due to their role in setting the framework of rules. Medical protocols. So medical protocols, all right, are those protocols being fulfilled properly in those organizations? If not, medical organization will be responsible. And players' welfare standards. Yeah. So claims against clubs or individual actors often fail due to lack of proximity, authority, or breach of clearly defined duty and whatnot. Okay, from the larger organization such as world organization or even national organizations. Yeah. So why are rugby governing bodies more suitable in TBI-related negligence claim than the clubs or referees? Because the governing bodies possess rule-making authority. That is where it is passed down to the smaller organization, national or clubs, and bear ultimate responsibility for regulating safety standard. Of course, we contrast with Watson. As I said just now, Watson in itself is a boxing, you can't regulate about, punching on the face. Don't punch anymore in boxing. You can't. That's not a sport. But in rugby, it's not. You don't punch on the face. You just focus on the ball. But you need to, be strong to be able to handle the, push and the knock from the other parties. So the bodily contact is very heavy. But the target is not attacking you, but target is to capture the ball from you. It's different. Okay. So referees and clubs act within those frameworks. Failure to implement protocol often lies with high-level decision makers. Yeah. So that is why author is targeting on the defendants. So we have Watson's case. Barrett and Ministry of Defense illustrate how institutional actors can owe direct duties when they assume control. These cases actually given some limelight because the courts deliberated the whole thing before confining themselves when the duty arisen and where the breach was, especially in Watson's case. So the legal trend is toward recognizing organizational liability. especially when a centralized body fails to act on known risks. Again, fail to act. That is the challenge that they are looking at. Having said that, I've done the first few lines of discussion now. Okay, hope this can assist in some way or another to reflect back the article that you have done. There are about, summary was about 10 pages, but the article is about 21 pages. Okay, cross-refer. You can cross-refer and jot your framework of notes, which will be very helpful, okay, by analyzing in a question perspective, what I'm trying to say, question perspective. And I'm giving some input as an approach for you to be, more equipped for the examination to what I could, because we can't predict what question may appear. Okay, I can set 100 questions, but it's not going to help to learn too many questions when we don't know what kind of questions. So at least we digest based on the possible way to think. What is this paragraph all about? What kind of questionnaires that we need to observe from here? And what is the objective of that paragraph? Then that will avail us to present according to what the examiner asking. Okay, whether the examiner asking us to explain, analyze, set opinion, what the author is thinking, all these are the ways that the examiner can assess. Or what are the authorities that suggest and competing interests that we could see from the aspect of defendant perspective or limitation. So those are the ways that they can ask you. But what is important? You need to know what exactly the paragraph is trying to say and what is our challenge, okay, from the author's perspective. Yeah. So we'll take a break now. Okay. We should be meeting up, say, in about 7 to 8 minutes, I hope. Before 12:50, we will come back. Not too long. I'll be back. We will continue from there. Right. I have resent the article in the event that any one of you did not have, right? So you can download it now. Because I have sent earlier, probably you may have missed the article there. So you can download and then you can refer. I'm at point number 3. We have done with 3. Point number 4, yeah. So now we are going into the substantive part of it. That is the duty of care. And again, right, the notion of assumption of responsibility was raised by what we call the authors here. So under this ambit, okay, in summary, what the author tried to say is that the establishing a duty of care hinges on proximity, foreseeability, and assumption of responsibility. But the author is not trying to limit the concept of assumption of responsibility because you do not really find, okay, a proper precedent on that. Okay, so hence, okay, they are looking into the range that, as you say, as you know, that the notion of duty of care has been, okay, evolved to the extent that, okay, there were 2 streams of tests for duty of care. One is Caparo stream and one more is Donoghue stream and one more is Hadley-Burn. But there again, it has been, intermingled to be used in various circumstances, in various ways. So author is not, okay, limiting that opening up the concept of, proximity, foreseeability, and at the same time, probably, okay, you may want to use assumption of responsibility. So the citation of a case made by authors Whirlpool and BC against GN, where the court emphasized the need for a defendant to have positively undertaken to protect the claimant. Okay, positively undertaken to protect the claimant. So the governing bodies may be said to have assumed responsibility, or maybe said to assume the responsibility by introducing safety protocols and asserting authority over return to play decision, right? Introducing safety protocol and authority over return to play decisions. So how might the courts find out? How might the court find? How are the courts going to deal with this? This is what the questionnaire that we have to ask ourselves. How the suggestion can be made here. That rugby governing bodies have assumed responsibilities for players' neurological health. So what is the prospective way that we are looking at? There is no precedent per se, but we need to come up with some ideas to, cap the dimension of the test that we can actually develop from what has been developed previously to this kind of situation, a new generational problem that we are facing. Okay, new generational problem that we are facing. So here, the objective assumption of responsibility establishes, all right, where players rely on regulatory bodies, expertise, and protocol in their setting of the rules. All right. And of course, a good observation that we can make, okay, is by trying to circumnavigate the close proximity or some level of proximity test that can be seen, which has been established in Henderson and Merritt syndicate. Okay, I think it's more like a chained franchises, okay, right, where the advice and the protocol and the procedures came from the main syndicate, we call, right, and the reliance could have been observed from your, okay, settings of the standards of the franchisees, right, where they are, even though you don't know them, there is no close proximity can be easily seen, but it is understood that there will be a reliance, and those are the class of people will follow your settings. But you need to reach further to include these regulatory bodies here. And also the case of customs and excise against Barclays Bank can be another relevant case to be considered, okay, in its approach. Right? Very challenging, definitely very challenging, because it's a bit more far-fetching, because even then, the courts are not willing nowadays, okay, not ready to go very far. But the damage suffered should, okay, instill and bring upon the seriousness of this compared to pure economic loss. That's what I'm trying to say. Compared to economic losses. But this is even greater, that, okay, requires urgent attention. Okay, require urgent attention because it's more of a serious personal injury. Okay. So the governing bodies often mandate concussion protocols. Yes, they do. They do recognize. We don't say that they don't recognize. Governing bodies do recognize concussion that occurs, right? So they imply control and reliance. They imply control and reliance. You cannot say governing body do not understand, because they know people will suffer. People will eventually, some of them will suffer this. So for that reason, okay, the proximity, even though you don't directly imply or know that these are the people, but generally the class of people are rugby players under your protocol. They are not rugby players outside your protocol. They are under your protocol. So that in itself, a chain of proximity that can actually be tackled, okay, and with the gravity of damage that has been suffered, that needs to be given prevalence to allow such proximity to be created. So the courts are moving towards, okay, recognizing this, okay, functional proximity, right? Not statements proximity, functional proximity in institutional context. How do they function? Okay, where authorities set a standard, they know that the reliance is created, okay, right? A de facto relationship of responsibility. So there should be a positive responsibility towards those direction. Of course, okay, if you fail to observe the rules, if you fail to observe those things, okay, then you should be responsible eventually to hold that you're liable for the losses that has been suffered by the parties, okay, under your rules, even though they are no longer in the organization, but they were in the organization. That's where the causation principle comes in later. Okay, but this is basically trying to show that, you know, whether, right, this responsibility exists during the time they were the members of the organization following the rules and protocols. Yeah. So that was the I think the key observation that we can look into is how the courts are going to observe, right, the test of duty of care, because this is under negligence. So the test of duty of care play a very important role, and we need to create a bridging, okay, observation about how a duty of care can be established on this account. But of course, it depends on case-to-case basis as to whether it fulfills the requirements eventually. But there again, some, okay, right, preset observation can be accepted, that there can be a duty of care in this set of circumstances. Not to say there's no duty of care. Duty of care has already been exist in sporting events like rugby. We don't say no. But in this set of circumstances, knowing the fact that there can be a far-fetching, okay, consequences occurred to these players. Right? So that is the point that we can observe, okay, based on the test that has been in existence and highlighted on the issue that raised by the authors here. Moving on to breach part, quite technical in the sense of what breach that you have done, okay? wide variety of issues to see, okay, what risks, because the rules in itself is not one rule or two rule. There are, various documentation to observe on your rules to see whether you have failed in certain parts that has actually eventually caused the harm or not. So breach involves failure to take reasonable steps. Failure to take reasonable steps in light of known risk. In light of known risk. Courts consider medical consensus, CISG's treatment, okay? Cause of precaution, this statement from the group, right? CISG's statements. Costs of precaution and whether action aligns with evolving standard of care. So the Bolam principle may apply. According to the author, the Bolam principle may apply. But are we able to supplement it by Montgomery when non-disclosure of risk is central? Okay. So the regulatory body should know what are the risks that can be, okay? I mean, there are many types of diseases people are facing, many types of diseases. Not all regulatory body be able to understand in 10 years down the road what new diseases people are going to suffer. But at this juncture, what people have suffered, what people are suffering is a benchmark, okay, from the medical profession to show the regulatory bodies that what are the measurement the body should take in making their regulation clearer to protect or to safeguard the future-prone injuries. We can understand, even in Bolam itself, okay, the injection of the phenol, the spine part of it, injection of phenol, the spine part. At that point of time, they did not know what could have been the side effects. Because at that point of time, the medical knowledge was limited to that extent only. But later, when you come to know that these side effects do occur, then the medical profession need to be a bit more cautious in their way how they recognize those risks and be able to set the rules accordingly and be able to provide for a proper informed consent when the parties are joining rugby games. Of course, it works both sides. You are also required to make sure that special measures are taken to avoid liability. To avoid liability, like Montgomery, you should be able to, disclose everything that is possible, then let the personal autonomy take priority to decide what the patient wants. You do not need to hold the autonomy. Let the patient to hold the autonomy. But what's your duty? Full disclosure of the risk. So when there is some form of responsibility or liability that can be released, that the regulatory bodies can be exposed based on this kind of latent damages, then we are actually, all right, telling or advising regulatory body to be more cautious in future, to be better prepared in future. So it becomes a balanced interest between both parties. And that is where, over and above, if the players are going on to take those risks and go on to play, then voluntary come into the picture. Voluntary is complete. Mere consent alone cannot. You must be able to consent not only to the physical risk, you must also be able to consent to the legal risk. At the moment, voluntary non-fit injuria is not a good defense. If for the matter, okay, right, that there is a duty of care means, voluntary is not a good defense. Now we don't have to talk about breach because duty of care in itself is not easy to be proven because of the latent damage. Your damage is after so many years. But if these things are changed, then of course, all these things will need to be observed carefully already on the part of the defendant, and also not giving too much of leeway to the claimant. Claimant should know, okay, what are the risks that they are taking while, going into this kind of sports. I think by now many people, they know already how dangerous these sports can be for the future in their personal welfare, sorry, personal health care. So that is basically that. By looking into the simple caption, we know this is something that from the authorities are highlighted, okay, by the authors. Okay, the disclosure of the risk becomes central to understand who bears the liability eventually. So now the question is, how would a court determine if a rugby governing body breached its duty of care in managing the TBI risk? So the courts weigh foreseeability, the known TBI risk, post 2001, available precaution, SCAT protocols, if you look into the article, return to play guidance, and social utility like Compensation Act 2006 and the Heroism Act. There's another act in 2015, if I'm not mistaken. Okay. Social utility. So we need to be able to work along the line between the common law and the statutory protection that can be seen here. So delay in adopting known protocols may indicate breach, especially, after 2012 CISG statement. That shows that, okay, do not take it lightly. It's time for more, okay, observation or more critical approach need to be taken because of the known risk can be seen already in terms of statistics that, okay, shown pertaining to people who are suffering from this kind of injuries already. And the medical profession already identified that these injuries are coming in and should be due to some contribution or causes made by the event itself, the sporting event itself. So how Lanarkshire, Montgomery emphasized duty to warn was risk of cumulative brain injury disclosed to players. All these things part and parcel of something that we need to highlight, which I mentioned just now. So the more entrenched the body's regulatory load, the higher the expectation of proactive evidence-based intervention. So by you, it is coming. So before that, you must also get yourself ready. That's what basically, right, author is warning, right, the defendants, okay, the bodies themselves. So that is on the part of a breach, the failure to take reasonable steps of no needs. But of course, initially, the failure part, omission part is always not something that is what we call easily adaptable to impose a liability on a defendant. Yes, it is understood. You talk about 1970, 80, 90, but in the 2001 onwards, when the knowledge increasing and you are directly responsible for many things, then now it's time for you to be more focused on those things where you're assuming responsibility means you must take necessary measure already, right? On those risks that is involved, right? Not a general, of course, like policeman, okay, right? He saw some hole or manhole that has been opened. Then, of course, he has some duty, but that is not his general specific duty. Specific duty is prevention of crime. Okay? So, but here you need to specify it for them already. It's time for the specification of the duty so that you are able to ensure that there is no breach occurs or less exposure of liability on the defendant part also. Okay, it's a balancing criteria here. Finally, the challenge, of course, okay, is on causation. Causation is a very challenging aspect. Why? Because you can't really determine, okay, these kind of losses based on but-for test. All right. But-for is very easy if there is one event, one defendant, one cause, doable on a balance of probability. But comes to this kind of latent event, not easy to identify. You may have more and more defendants. Some are contributed by yourself also because you're playing the game. So where the line to be drawn or what kind of test to be used? So that has also been highlighted by the author. In summary, causation is complex in long latency claims. Traditional but-for tests may fail. Courts may use material contribution, as in the Bonington's case, right? Doubling the risk or Fairchild increased risk where harm results from cumulative exposure. So Bonington's test or Fairchild test might be something that is alternatively can be used or can be used as your main test for causation. You can't really use but-for test. In the normal event, accident, incident occurred as something beyond the rule, then you're suing the referee or any, the but-for test is possible. But this is quite similar to, okay, duration, quite similar to accumulation, okay, which cause some latent issue, which cause some later issues, right? Though not as short as, Fairchild or even Bonington, but still, right, there is an issue that can be linked to the, right, incidents that occurs during the game. So the cumulative exposure comes in means, right, then it's fair enough for us to use Bonington and Fairchild. Not Wilshire. Wilshire is one of reason which did not fulfill the but-for test. Okay, but this can be due to cumulative impact to your head. Sometimes one impact good enough. On a long run, it can cause the harm. Sometimes you need to go through a cumulative impact to your head. Then it has become a disease for a person. It depended upon what kind of concussion, what kind of issue, what kind of disease that is that based on the medical, okay, evidence. So the question is, what legal approaches may courts adopt to establish causation in rugby-related brain injury? So in terms of guiding ourselves, okay, in the event, okay, most likely they're going to ask similar type of situation already. They're going to talk about causation, they're going to talk about breach and so forth already. But what is the approach? What legal approach here we are talking about? So we can develop our answer from material contribution to cumulative TBIs, from poor return to play protocol breaches aligned with Bailey against Ministry of Defense logic, right, which has been highlighted by the examiner. You can use that point. Epidemiological studies, example fields, support doubling the risk of NDDs in professional rugby players. Epidemiological studies. That means nowadays, the medical profession is advanced enough to do epidemiological. That means they should be able to identify some causes that has actually eventualized into this final risk. Even though, albeit not on a balance of probability, but yes, there is. Probably it has actually increased the risk or contributed to the risk of harm that you are having now. So Fairchild reasoning may apply in this kind of set of circumstances. So some comparison need to be made about Fairchild, about Shonquit's case, about this Fairchild case in itself. Also looking into the case of Lord Briggs in the case before Fairchild, about this brick kiln case, actually. Can't remember offhand what case was that. The brick dust causing dermatitis. Yeah. So, of course, Fairchild is a ruling authority, on the newer dimension of causation if but-for test fails. Fairchild is argumented. Okay. So can we use that? Yes, it is possible. Why not in sporting activities? Why not? So the law is trending towards claimant-friendly tests, where scientific complexity makes definitive proof unfairly burdensome. So, yeah, causation part will be one such prominent area that examiner may ask you, right? Out of 7 or 8 areas I'm highlighting, okay, I won't be surprised. So hopefully the 4 questions or 3 questions they're going to ask you will reflect some of these areas, right? Second defenses. Yes. Volatile non-fit injury and CN contributing negligence are likely defenses if this can be brought forward. All these ideas and recommendation and diagnosis highlighted can be brought forward. However, genuine informed consent is rare if risks were undisclosed or misunderstood. That is one of the reasons. So there must be a clear guidance of the risk to be disclosed. That's why I say all these things on a progressively you are setting a standard and you are tapping and you are overcoming it. Then comes to defenses. The realm of defenses may change. How to go about. So injured players may have impaired judgment at the time of injury because they don't know earlier. So that was the issue. So we need to assess the viability of voluntary and contributing negligence in rugby. So we want to have a clear balance. To have a clear balance, we must impose a liability so that there will be a constant improvement in making sure the rules are being highlighted, the risks are being shared to the players, right? So to answer guide on this area, few authorities and points to note, namely number one, voluntary requires informed voluntary consent to the specific risk, not just a physical risk. It must also be a legal risk. It is difficult if governing body fail to warn, right? And they need not warn, okay? But now you need to impose that the warning is necessary, full disclosure is necessary, right? As opposed to the cases like old cases like Sims against Lay Rugby Football Club. And contributory negligence also weaken if the claimant played under influence of head injury, team pressure, or inadequate protocols. So it is not, he is, exposing himself, okay, to such a risk that partially also is fault. Now, I think players do not do that. They don't simply go and expose themselves to the risk. The game in itself consists of such a risk, right? But they are not, okay, happily going into, right? There's a pressure. All right, there is a pressure because of this is a game. You want to win and protocols are not said what to do. Some other players may go against attacking you, but it's within the protocols, within the rules. So the rules are not set properly, then you are prone to injury. Oh no, you cannot have the rules are already good enough. Then why people are suffering latent damage? It's all interlinked to argue. Interlinked to argue. So these defects reflect individual responsibility again, right? But the legal shift toward institutional accountability may rebalance form. So yes, it's a shift to the individual, but there again, by setting all the standards right, then individual will have a right to make a better decision to decide whether voluntary should be applicable or not. So younger and medically dependent players, yeah, are especially unlikely to be treated as voluntary because they don't know the legal risk. They know physical risk, yes, but they might not know what is a legal risk. So it is important to now, okay, look seriously onto those kind of issues under negligence for latent damages by the rugby of the rugby players. Yeah. Finally, strategic framing and likely success. So, of course, author did some strategic points eventually. The claim should focus on specific omissions, not a general omission, specific omission, failure to monitor, response to known concussion, or any others. Okay, so there must be a specific omission issue that can be framed for this rather than general failure to protect. No, more specific is required to balance the rights of the defendants and the claimant. Strategic framing around post-injury failure aligns with modern duty doctrine and overcome policy objections to indeterminate liability. So we are trying to let the liability comes in at the same time. We do not want, okay, floodgate by setting all the segments of the law to be rectified and put into a proper structure. Okay. So putting the moving forward approach. So the article is not saying that, oh, now these people are suffering harm, no claims has been done, so we are going to, the law should make the defendant liable, governing body should be responsible. No, they are saying yes, we need to bring in, but at the same time, we need to set everything standard to balance between both organization and also things. So it's time for us to move forward towards that direction because latent damages are seen to be very apparent already, not just closing our eyes. We shouldn't do that. That's all. A law need to be framed clearly and structured properly now on this area. Something like Wilkinson and Downton also. Last year's article also. Same issue. A very good law which can cover the loophole of many areas, but it became redundant over the years and it should be revived, okay, to cover certain problems faced by the society today, especially due to the kind of diseases and harm people are suffering, okay, compared to those days, they call. So it's a very good rule, old rule, but it was not recognized because more often than not, they are not looking into that. Okay, it doesn't cover or they don't cover because they expect other laws are covering successfully. But author is saying, no, here there is a serious, okay, call to revisit on the players who are suffering latent damage. And of course, rugby is a very popular sport in the United Kingdom. So that's where we need to, like you know, asbestos does. It's a popular industry. Why Compensation Act came in? Why Fairchild came in? Because we need to protect the people because they are vulnerable to that disease. Asbestosis can eventualize into mesothelioma, okay, which is a form of a lung cancer, right? Why? Can you close down the factories because people are suffering this kind of harm? No, you can't because it's a industry that generate economy for UK. So the law must be there to protect the litigants, or rather the claimants. That is where Fairchild came in. That's where Compensation Act came in, specifically allowing for such a claim for mesothelioma. So now we are facing another domain of national interest, that is rugby players. So we need to have something got to do with that. We need to have something got to change the framework of the law to protect these interests. So the answer guide in this kind of strategy situation that we talk about narrow the claim, yes, focus on the post-injury mismanagement, right? Not general risk of sport. Try to cover as much as possible in a very narrow ambit, not too broad. Use of player medical reports, expert evidence as part of the data, right? Or protocol should show failure to follow evolving best practices, to show that there needs to be a proactive engagement by the governing organization to start developing this. Anchor causation in identifiable regulatory failures rather than cumulative impact alone. So the reflection is aligning claim with legal concept like institutional omission and assumption of responsibility strengthens coherence and judicial receptiveness. Because you cannot cite one party only. Judicial receptiveness won't be there. Law has to balance both sides. So on that account, okay, I believe that the summary and reflection and the way that we need to analyze the paragraph and the questions will provide some level of help for you to work on it, work on your reading, summary given by our counterparts, and then you put together to show that how you can actually answer those questions in part A if it is applied. I think you will be focused on this kind of directions, the examiners. We hope. And it's not a conclusive question. This is just a suggested style of what you need to expect, you can expect from the examination. Having said that, I have also done with the article. We have another 5 more minutes only, right? Let me just run through the public bodies, which is not a popular area, right? Even if it is so, probably you may want to read my, information so that you will be getting yourself ready, yeah? So let me quickly share. We have a couple of minutes, but meanwhile, you have any other question, feel free, openly, you chat first, while I'm quickly run through to ensure that we cover what needs to be covered. So public bodies know the recent authority anyway. No recent authorities is a matter of basing on the earlier questions only, right? From 2021, sometime, I think 2021, you would have done it during your normal class. I believe so. But I just want to show you that in 2021, there was a question, but the recent trend, no questions, huh? Right? And the questions are normally, conceptualized into either you are the questions talking about the police, all right, or question in general, like pure economic loss and negligent misstatement. More often than not, police will be the focus for the examiners, if not general public body question. Yeah. So this is one with authorities that I've actually put forward for your reading purposes. Okay, all these are from is most importantly when it comes to police. The main authorities are this one. The main authorities you can see, Michael, and then Robinson, the latest one I would say, Robinson's case. These are very important key cases, I would say. Michael, where Lord Tolson decided Hill was the blanket authority given. That's where everyone is challenging Hill, right, against Chief Constable of South Yorkshire, the core principle of blanket immunity, they call. And then you have a bit of a development from Van Cole and Osman. And then Smith came in, okay, considering how the court's analyzing negligence on the part of the police. Robinson is the main authority today, 2018 Supreme Court. Okay, so this is the key authority that we need to observe for perspective of police liabilities today. Yeah. Application and evaluation of the principles. This is a suggested, okay, observation. Earlier was authorities and information on it. This one is the flow that I can suggest. And then in 2021, Zone B, there was another question. Question 2, also essay, but this is a general question, not a specific. So it covers police and others. Like, for example, we are talking about local authorities here on omission, right? And then we were talking about the police also. Stowin and Wise is also about the local authority on the roads. Stowin and Wise. And then moving forward, Carmarthenshire County Council against Lewis, 1955. Not a police authority, but a general issue. Bharat Ministry of Defense, 1995. Soldiers' Duty, Tomlinson. And then comes to police. I've also highlighted police as part of the answer. Robinson is here. Checking with others like, fire brigade. Okay. What we call this, a daycare home, under the local authority or local home office. All these are cases involving a general duty of care by omission, okay, as to whether public body should or should not be liable. Okay, and the outline of it, quick reading, and then that's all. So after that, no question, the way I look at it. So I don't see, public bodies seems to be very focused by the examiners in these recent years. Especially, we are focusing on privacy law and other related. I think negligent misstatement coming back. Okay, there was a bit of a gap in between. They were giving some problem questions earlier in 2020 or 19 or 18. But now the examiner's trend is moving towards an essay questions. But I won't be surprised suddenly they can come up with problem question again. But if you're ready to prepare an answer for that for the examination, then do so. Doesn't matter. And of course, your main focus is part A article revision. Yeah. Okay. Having said that, I'm done with the 3 days of intensive revision workshop for Hong Kong on the topics that we need to cover. I hope that you have a takeaway and benefit out of this 3 days session that I was assigned to do. As I said, you have the time to email me with the time that I have. Okay, I will always reply you, be able to reply until your examinations. Right. So with that, I wish you all the best. Any questions? 1 minute to go. Right. If there is no question, then we shall be able to call it off for the day. Thank you very much and have a great day. Bye-bye.